anything. So I'm kind of confused myself, because some legal analysts say that why didn't she just tell it? Like, why didn't she just reveal it? And then it would have been more above board. But at the same time, everybody knew about it.
And while we're going on this train of the text messages that have come out between Merchant, one of the defense attorneys, and Bradley, is one of the things that came out is that Merchant had said to him, Fani Willis should just step down, and that Merchant had said, well, no, she's just going to go down in flames, holding on to Nathan Wade, something to that effect. And she obviously currently does not want to step down. She's fighting for her right to stay in the job. What do you think? Could that solve any of the problem for her? Because facing disqualification must be a far worse thing.
Well, I think she feels that she can win this, because it's not really a cut and dry case, right? They have, I think, have established that this relationship was going on before he was hired. I think that's pretty clear, and the judge can determine that from the evidence that he has so far, but it's not so clear that she was benefiting financially. Now, if the judge decides that, she's not a credible witness, Nathan Wade's not a credible witness, they both have lied to the court, then that's going to weigh against her, because why would he believe her that she paid everything in cash if she lied about the relationship?
Yeah, because we do have another witness who came to the stand previously, the former friend of Fani Willis, Ms. Yurty, and she also testified to the relationship starting before Fani and Nathan had both said that it started. Right. So there's that corroborating evidence in a way, or testimony. But what we don't know is, I guess, what you're saying is the issue of whether she profited, and what we're expecting is this issue of whether she actually did pay for half of the trips that they took together and things like that. She's saying it happened with cash, and we are expecting to hear testimony. How much do you think one instance of one worker at a winery saying he witnessed Fani Willis paying with cash could weigh into this question of whether she benefited?
Well, I mean, it only shows that she paid for this one item, right? This one occasion. And I think she did say that it was his birthday and she paid for everything on that one trip. But there's also a lot of information in the text messages that say they went on a lot of trips. They went on several trips, to Florida and California and different places, and they went, out of the country on trips. So that one trip, I don't think is going to weigh heavy in her favor in terms of, whether she paid cash or not. The only thing she has is her father, who confirms it, right? Her father testified that this is what he taught her ever since she was a young child, to always have money in the house, and he corroborated that. But it's up to the judge to determine whether or not she's telling the truth.
And Arlene, another thing that came out since the last hearing on this about 2 weeks ago now was this cell phone data from Nathan Wade. Can we talk about that a bit?
Sure. So today, one of the things they're going to discuss is whether or not those phone records should come in as evidence, because, of course, the prosecution is objecting to this coming in as evidence. They're saying it doesn't prove anything. He could have been anywhere in that vicinity where she lives. There's airports and restaurants and so forth. It doesn't prove anything. But from my notes, this investigator who reviewed these notes, these records, he prepared a report. He prepared a report providing a detailed analysis of the voice calls and text messages. And he said that between January 1st, 2021 and November 1st, 2021, when Nathan was hired, so that's an 11-month period, using geolocation data, he determined that Nathan Wade had gone to her condo 35 times. And he zoomed in on the towers that are near where she lives. And I don't know how they do it, what method it is, but based on this method that they used, he determined that he was actually at her condo 35 times. Now, Nathan Wade testified he had only been there maybe 10 times at the most, and that he would go there to visit Miss Yurty, or he would go visit Miss Willis to review some documents. Miss Yurty testified that she didn't live there with Miss Willis, that she turned it over to her and then she left, and I think she got married. So he also said that there were over 2,000 voice calls and 12,000 text messages exchanged between them, and there were some late night visits, like 11 p.m. to 4 a.m. in the morning. So, if they weren't together at that time, it's a little damaging, I think, to show that he was there so many times and there was so much communication between them and late at night.
Now, as we heard earlier in our coverage this morning, some of the viewers, we asked people out there what they think about this and whether they should face consequences for it. Some people had said, yeah, if they're breaking the rules, okay, they should face consequences. Others couldn't really see why it would be a problem if they had a romantic relationship. If we could take a step back just for a moment and just recap for viewers, what really is at stake here in terms of why people should care about this case?
So in terms of a romantic relationship, that in and of itself is not something that should make them lose their jobs. If you're just looking at a romantic relationship, and as Fani Willis says, you know, white men do it all the time. They always have women and they're doing all these things. Why are you picking on me? You know, picking on me because I'm a black woman. This is one of her defenses, right? But the thing of it is, not only were they in a relationship, but she hired him. And this is something Ashley Merchant says a lot in the text messages. Why did she hire him? And he's a man that has no experience handling a huge case like this, let alone a felony. Why did she hire him? The other part of that is this money aspect of it. It's very suspect, you know, whether or not she and he are benefiting financially because of this.
Okay, well, that is a great recap to begin with. And as we can see just here on the screen here, the hearing is beginning. We do have some speech happening right now from, who is that we see
This is
here?
Ashley Merchant's husband. Ashley
Merchant's husband. Did we see him previously?
Well, he's co-counsel with her, so I don't know if she's in the courthouse or not.
Okay.
And maybe he's beginning.
And Ashley Merchant, of course, is one of the defense attorneys representing the case. She's been the main one at the forefront here driving this hearing and the questioning from that side.
And let's tune into the hearing.
Forensic misconduct, but those are the two lanes that we're going to be covering, but I'm going to do the conflict piece of it for you. And on that issue, Your Honor, this is a matter of first impression in Georgia. I can't find a single case that's been published by the Court of Appeals or the Supreme Court that is based on these facts. There are, of course, a number of different appellate court cases that deal with conflict-related issues, and more importantly, appearance of conflict-related issues. And some of those are based in state law. Some of them are based on the ethical rules that govern lawyers. Some of them are based upon the Sixth Amendment right to due process that's implicit in all of what we're doing here today. I want to remind the court that we're here today on this motion to disqualify DA Willis and her office because of her judgment, frankly. She is supposed to be disinterested under the Sixth Amendment, and she's anything but that. The fact that these proceedings have taken this long and through the convoluted way we've made it here today explain that. So as I present my arguments, I want the court to understand that this court represents the guardrails for the Sixth Amendment in this context, and Ms. Willis has already been disqualified once. So I would encourage the court to remember what Judge McBurney did in his order disqualifying. The same argument was made in that case as to whether or not there needs to be an actual conflict of interest or whether or not the appearance of a conflict of interest might be sufficient under the facts. I want to make clear to the court that the law in Georgia suggests and is very clear that we can demonstrate an appearance of a conflict of interest, and that is sufficient. There is, I'm going to be candid with the court, there is a Supreme Court decision from 1996, Lambie State, and then there are two Court of Appeal decisions after that deal, frankly, in some dicta that suggests that an actual conflict is required. But the Supreme Court of Georgia, since those decisions came down, has made quite clear that the appearance of a conflict standard still applies. And the reason that's important is I think under the Sixth Amendment, which is where we're at, in order to preserve the defendant's rights under that provision and under corollary provisions of Georgia law, you've got to consider the appearance of a conflict. And the reason why the appearance of a conflict is so prescient here is because if this court allows this kind of behavior to go on and allows DAs across the state by its order to engage in these kinds of activities, the entire public confidence in the system will be shot. And the integrity of the system will be undermined. And so with those sort of public policy and constitutional principles I wanted to turn to the law in Georgia on disqualification. And Your Honor, I'm going to give you the law, and then I'm going to talk about the facts and how they apply to the law at the end. If you want to talk about the facts earlier, jump right in, and I'll be happy to do that. I'm sure Your Honor is very well prepared and probably knows all the law that I'm going to cite to you. But to give the skeleton outline, the original seminal case that deals with conflict of interest from the Georgia Supreme Court is Williams v. State. That's 258 Georgia 305. And there are basically two methods by which you can disqualify a district attorney. One of them is a conflict of interest, and I'll suggest to the court that doesn't mean an actual conflict. That could mean an appearance of conflict as well, and then forensic misconduct. Importantly, in the Williams case, though, in footnote 4, and I think this is important for the court's analysis about the facts and which box it fits into, the court said there was no clear demarcation line between conflict of interest and forensic misconduct, and a given ground for disqualification of the prosecutor might be classifiable as either. And I think that's important because we have facts that fit in both boxes. So if a state stands up and says, well, there's no actual conflict here, Judge, that doesn't mean necessarily that it doesn't apply to the forensic misconduct. Typically, forensic misconduct relates to statements of the prosecutor designed to impugn the character of the defendant before trial and to affect the jury pool, which we have here, which I'm not going to discuss, but the facts that we have here very much relate to that issue, and there's crossover. Importantly, and I think this is important for the court's consideration of what effect the court's ruling may have, is if you deny this motion, there's a good chance, if it's reversed, that we would be granted a new trial. So that means we're going to have to do this all over again. In amusement sales versus state, 316 Georgia Appellate 727, that's a case that cites Whitworth, which is physical precedent only. The court said, if the assigned prosecutor has acquired a personal interest or stake in the conviction, the trial court abuses its discretion in denying a motion to disqualify him, and the defendant is entitled to a new trial, even without a showing of prejudice. So that means if we show the court today, and I think we have through the proceedings today and before, that Ms. Willis has developed a very personal interest in this case, and Your Honor denies this motion, we're coming back all over again if the appellate court say you were wrong.
So what is that personal interest?
So the personal interest can be, there's no definition of that under Georgia law, and it could be a personal financial interest. It could be a personal interest related to bias against a particular defendant, which sort of falls into the forensic misconduct box. But we have here a very personal financial interest that's been laid out in terms of money received by Ms. Willis as a result of the scheme that she set up. But to get to the issue of the personal interest in the context of an appearance, I think that's important. I do want to suggest to the court that there are a number of cases that post-date this actual conflict of interest language that's suggested in some of the cases from the 90s, that you have to pay attention to what this looks like to the public. And I agree with all of the law, and I'm sure the state's going to stand up here and say it can't be a speculative or a conjectural type of personal interest. We don't have that here. We have something very concrete. And as Judge McBurney put it, actual and palpable, not speculative and remote. That's exactly what we have here. We've demonstrated through the testimony of the witnesses, some of whom impeached themselves, that we have a very personal interest. In the seminal United States court case that deals with prosecutorial impropriety is Young v. U.S. That's a 481 U.S. 787 case. In that case, it's the opportunity for conflicts to arise that created at least the appearance of impropriety. And that's the case that requires that the prosecutor be disinterested. Since a scheme injecting a personal interest, financial or otherwise, into the enforcement process may bring irrelevant and impermissible factors into the prosecutorial decision. Now, there are a number of Georgia cases that sort of repeat that theme. Reeves v. State, 231, Georgia Appellate 22, that's a 1998 case, stated a potential conflict of interest existed and the appearance of impropriety existed. Davenport v. State, 157 Georgia Appellate 704, that's 1981 case. That was decided 7 years before Williams. When there is at least the appearance of impropriety, a defendant is denied fundamental fairness in the state's prosecution of the charges against him or her. There are also rules that govern prosecutors. Lawyers in general are bound to preserve and avoid even the appearance of impropriety. That's Brown v. State, 256, Georgia Appellate, 603, 202, 2002. Head v. State. A prosecutor's close personal relationship with the victim in a case may create at least the appearance of a prosecution unfairly based on private interest rather than one properly based on vindication of public interest. ABA Criminal Justice Standards for the Prosecution Function, Standard 3.3-1.2c. A prosecutor should avoid appearance of impropriety in performing the prosecution function. 3-1.7f. The prosecutor should not permit the prosecutor's professional judgment or obligations to be affected by the prosecutor's personal, political, financial, professional, business, property, or other interests or relationships. So the rules that govern her in her own profession say that this is wrong because she's developed a financial interest in this case. And at the very least, created the appearance of unfairness towards these defendants by setting up a relationship, a prosecutorial relationship with her boyfriend that she'd been dating for 2 years, according to the testimony. So before I move, Your Honor, to the specific facts, you asked, what's personal interest, and I think, frankly, as I was trying to figure this out, I think you know it when you see it. It's just like in the concurrence in Jacobellis versus State of Ohio, Supreme Court case from 1964, Justice Stewart, in his concurrent opinion, said, "I know it when I see it," talking about obscenity. I think you know it when you see it. I think there's enough facts in front of you that you know it when you see it. And so I think that governing principle helps enlighten some of the facts here. And also, I think it's not just financial. In McLaughlin v. State, I think the court's very familiar with that case, 295 Georgia 609, 2014. The Supreme Court essentially said that because the acting DA had become a witness in the case and developed a personal interest in the case due to his daughter's relationship with the victim, that he was disqualified. And because he was disqualified, his entire office was disqualified. So turning to the facts of the case, Your Honor, I think I've got, my role is 20 minutes, so I've got about 8 minutes left. So why the relationship, why did we spend so much time on a relationship between these two people? We frankly couldn't care less if they had a personal relationship outside of work. That is not what the issue is here. The issue is that they began this relationship in 2019. They were dating for 2 years. And then she awarded him a contract where public money, either from Fulton County or the state of Georgia, ended up in his pockets. That decision alone was improper. But what's even more improper is that then she and he used that money to go on personal vacations and trips. If Your Honor will remember, Exhibits 9, 11, and 12 dealt with the expenditures by Wade on trips. If you do the math on that, if you look at what he spent, and then you look at the testimony about what was paid back by Willis, because the cash reimbursement theory, I'll talk about in a second, but if you do the math on what he actually paid for it and what they testified she paid back in cash, you still have over $9,200. $9,200 and $9,247 to be exact is the amount of money they cannot account for in their testimony. And as Your Honor will remember, there was no mention of cash in Mr. Wade's affidavit when the best and first opportunity to raise that issue would have come up is when the state filed their response in his affidavit. That is nowhere to be found in there. The first time we heard about cash was here in this courtroom. And so I think she's received a personal financial benefit of over $9,200 in this case that she can't account for, and the state can't account for. And the reason we can't account for it is because they came up with a cash theory. Cash theory only raises. Before we get into that, let me ask you this: let's say they couldn't have. Let's say the theory wasn't even there that they had
paid it back or that there had been any exchange, should there first be a consideration of a materiality requirement?
No.
Have you seen that in this jurisdiction? It's not in this jurisdiction. Have you seen that in any other jurisdiction?
I haven't seen that, Judge. And if it was $6, that would still be improper.
Would it be improper where it's a per se disqualification if someone, buys their boss a stick of gum? Is that per se disqualifying because there's no materiality requirement?
Well, no, I don't disagree that it may not meet a materiality requirement, but it's a personal benefit. I won't say that giving me a pack of gum is just justification for disqualifying a district attorney. I think that's part of the issue, Judge. I think it's a fact-based inquiry by you.
So there's a continuum involved here.
Yeah, but I think the continuum involves you looking at whether or not, in the grand scheme of things, it violates the Constitution, and whether or not there's an appearance of a conflict, and the appearance suggests that she actually received a benefit, and we know that she did. They admitted it. We don't have to speculate about that. They said that she said she got a benefit, and she said she paid back certain amounts. So in that regard, Your Honor, I don't know, would $100 be enough? Would $200 be enough? I think you have to look at it globally and consider all of the witnesses, consider all of the facts, consider the credibility of the witnesses, frankly.
Right.
I mean, Your Honor sat here and watched everybody, so I haven't spent a lot of time going into the specific testimony because Your Honor is well aware of it. But you get to evaluate the credibility of the witnesses as a fact finder. And, just
from a legal perspective, though, you're saying we can't just say dollar amount, look no further. There has to be a totality of the circumstances analysis.
I think it's fact specific, Judge. I don't really want you to pin me down on that because there's no law on it. I can't give you a straight answer because I haven't seen anything like that. And I think if we build a materiality requirement into the case law, then you're down a slippery slope then, because then it's going to be the appellate courts are going to be deciding, well, is $50 enough? Is $100 enough? So I think it's not necessarily the amount of the money; it's the fact that she received it, and it's not insignificant. And I don't think your order has to say because she received $9,200 she's disqualified. I think if we go back to the 20,000-foot level, what's the appearance here? Is this fairness to the defendants? Does it appear that she is interested in this prosecution, or does it appear that she's disinterested? She took the stand. You can tell she's not a disinterested person when it comes to this proceeding, but we also argue she's not a disinterested person when it comes to the prosecution as a whole. I'm going to leave for, I'll resist the temptation to defend my wife, who I believe to be an excellent lawyer and a member of the bar for 20 years in good standing. But I will say this, Judge, you don't just evaluate the credibility of the witnesses. You evaluate the credibility of the lawyers. And Mr. Abadi stood up here in open court in front of national news and the national public and called her a liar. I need to address that for 1 minute. The text messages that are now part of the record, which now are substantive evidence for you to consider, prove everything that she put in that motion, everything that she tried to elicit from Mr. Bradley was absolutely 100% true. And not only was it true, she verified through the witness himself that the motion was accurate before it was filed. So for the state to get up here and impugn her credibility, it's not only improper, it violates Berger versus United States, which is a case that says the state can't just get up here and make any argument it wants. And I encourage the court to call him out on it when he steps up here. We have to have candor towards the tribunal. You cannot lie to the court, cannot lie to the public, cannot lie to the jury. And I think that's what he did. So there's other corroboration of our view that she was in this relationship. I think, frankly, based on Mr. Bradley's testimony, Your Honor can separate the wheat from the chaff when it comes to credibility. But Mr. Bradley had 2 chances to correct information that he suddenly developed amnesia about, but he just didn't do it.
How does the timing of the relationship impact a financial interest?
Because it's part of the scheme she created intentionally in order to give benefits to her boyfriend. So there's a reason why they fought so hard on this, Judge. I mean, there's a reason that every single subpoena was objected to. Every single question we asked Mr. Bradley was objected to. The jumping up and down, all of the obfuscation. There's a reason for that. They know that if Your Honor finds that relationship started in 2019, that the appointment of Wade itself was improper. And if that was improper, then he had no business as an average citizen, along with the fact that they didn't have approval from Fulton County to appoint him in the first place, that undermines the indictment. It creates a structural impairment in the indictment because he had no more business being in the grand jury room than I did. So that's what they're worried about. And the reason why it's important for the financial piece, Judge, is it's how the money ended up going back to her. She put her boyfriend in the spot, paid him, and then reaped the benefits from it. That she created the system and then didn't tell anybody about it. She didn't even tell her dad about it. So I think if in the grand scheme of things, if you're looking at the totality of the facts, and I've got to sit down here in about 2 minutes to make room for my co-counsel. If you look at it, everything put together, judges, they did this, they knew it was wrong, they hid it, and even when they were called out on it, they tried to create an excuse for it by saying it happened after the fact. We know now from the testimony, Ms. Yurty confirmed that Mr. Bradley, his text messages were accurate, not his court testimony, but that fact was accurate. The motion is accurate. And so also I do want to point out there's no paper trail here for the cash. I know that this was I know she and her father both testified that they kept cash on hand, which, I mean, keeping cash on hand in and of itself is not a problem. When you're a public official and you're required to keep track of gifts that you receive, then you need to keep track of it. But there's no paper trail. There's no deposit history. There's no withdrawal history. There's no receipts. None of that. So even assuming their testimony could be credible, and we don't think that it is, you still don't have enough information to track all that money that she received. And this is just what we know about.
But does the lack of evidence fall on the state? Does the lack of evidence fall on the state? Isn't that where burdens come in?
Yeah, yes, I think they had an obligation to tell Your Honor, hey, this is where the money went. And they certainly had the ability to do that if they could do it. Since they didn't do it, we have to assume they can't. And if they can't, I just want to remind the court of a very important piece of testimony from Ms. Willis that I think goes to credibility of all of the officers of the court who testified. She met with Wade, and they developed in 10 minutes after talking about the financial piece, I believe, this cash theory that could not be rebutted. We have no ability to do that. They did, and they chose not to do it. So with that, Your Honor, unless Your Honor has more questions for me, I'm going to sit down and turn the podium over to my distinguished colleague, Mr. Sadow.
Thank you, Mr. Merchant.
Appreciate the court's time.
Good afternoon, Your Honor. I'm going to speak to what I would call a subset of forensic misconduct. And I'm going to assume that all the law that's been provided to you in pleadings as well as emails, you don't need me to tell you what the law is. So I want to just set up how the disqualification and then dismissal of the indictment should take place under the subset of forensic misconduct. Roman's counsel, Ms. Merchant, filed on January 8 her pleading, her motion to dismiss and to disqualify. We were in court that Friday of that week in which I made it known that that is President Trump, may adopt that motion. I wanted to see what was going to happen before I did so. That Sunday, which would be January the 14th, 2024, D.A. Willis took it upon herself to go to a historic black church in Atlanta, having not responded at all to the motion of Ms. Merchant's client, Roman. And she made what we now call the church speech. And Your Honor has reference to that. You didn't necessarily want evidence on that, but you know what the church speech was. It was videoed. It was clear that Ms. Willis had notes. She was reading from notes that she had prepared. It was a calculated determination by Ms. Willis to prejudice the defendants and their counsel. How so? By making an issue out of the fact that the person that was challenged in the Roman motion was black, without telling the public or the church members or anyone for that matter that the reason that Mr. Wade was being challenged was not because he was black, had nothing to do with race. It had to do with the relationship that had been alleged and later admitted to by Ms. Merchant. Ms. Willis took full opportunity to prejudice the defendants, and then comes along later in a pleading and says it wasn't designed or intended to be at the defendants at all, or the defense counsel, which with all due respect is just nonsense. The purpose of that was to get public sympathy, public empathy for what Ms. Merchant had already alleged in her motion. Now, that was a violation of the professional rules of conduct. It was a violation of 3.8G. There's no question about it. It wasn't in response to anything that was said. It was a public statement, extrajudicial, for the purpose of making a comment upon the defendants.
It would be in response to a motion that was filed.
But it wasn't filed in a response, in a pleading. It was filed in response to a motion. And the motion were allegations made. If Ms. Willis wanted to respond at that point, she could have said the facts of the matter. Instead, she misstated what the situation was, took advantage of the opportunity, an ethical violation, and the ethical violation makes it clear that you must refrain from making extrajudicial comments that have a substantial likelihood of heightening public condemnation of the accused. Can you think of anything more that would heighten public condemnation of the defendants than alleging that defense counsel and the defendants were making their motion based on race and religion? That's as bad as it gets in Fulton County, with all due respect. That's exactly what Ms. Willis wanted done. And remember, the state still had not responded. So then what we get from the state is we get an affidavit filed as part of their response. And that affidavit says specifically, and the affidavit is Mr. Wade, says specifically in paragraphs 26 and 27 that the relationship did not begin until 2022. It acknowledges the relationship and says it didn't begin until 2022. And the pleading that's filed, the state's pleading in response, indicates not exactly that, but it says there was no relationship as of November 1 of 2021, and that's on page 7. So now we know that timing is the issue, because Ms. Merchant made it clear that we alleged and had evidence that indicated the timing was before Mr. Wade was hired, not after. So the state now has filed an affidavit and a pleading that claims post-hiring into 2022. And then Mr. Wade will testify to the same thing under oath. Now, Ms. Yerty says it began in 2019. Why would she know? Well, she would know because she was a former friend. I know the state's going to get up here and say you can't believe, essentially what they're going to say is you can't believe any defense witness because they're defense witnesses. And only people that would tell the truth would be Wade and Willis. I suggest to you that that's not accurate. I suggest that the testimony that Mr. Wade gave and Ms. Willis gave, and I'm specifically dealing now with the timing issue, without getting into anything else, that brought forth a true concern about their truthfulness and being what is required of a lawyer in this state, which is candor toward the tribunal. And that's 3.3 of the professional rules. Specifically, small a1, make a false statement of material fact or law to a tribunal. So that's, as I posited to the court, that's the second ethical violation. And then you also have 8.4 of the professional rules. It says it's a violation of the Georgia Rules of Professional Conduct for a lawyer to, and that's A4, engage in a professional conduct involving dishonesty, fraud, deceit, or misrepresentation. Now, do you have to find that Wade and Willis lied? No. What you need to be able to find is that there is a concern, a legitimate concern based on the evidence in this case about their truthfulness. A legitimate concern about the truthfulness, which equates to an appearance of impropriety. Because once you have the appearance of impropriety under forensic misconduct, the law in Georgia is clear, that's enough to disqualify. So, why should you find there's a concern with their truthfulness? ERT is the first one. You have that testimony. But then we go to what is the most obvious indication that Willis and Wade were not truthful on the point of timing, and that's Bradley. Defense Exhibit 26 came into evidence. Defense Exhibit 26 comes in and says, and you know I went into this the last hearing. It says that on January the 5th, 2024, at approximately 9:49 a.m., there's text messages that are exchanged between Ms. Merchant and Mr. Bradley. And the text messages go like just date, and that's from Ms. Merchant. Ms. Merchant says, do you think it started before she hired him? Bradley, who we now know from Defense Exhibit 39, has been texting with Ms. Merchant for a number of months. This is not the first time. This is months within the communications between the two. Mr. Bradley says, absolutely. Now, absolutely is not a speculative word. That's not speculation. That's a definitive statement. And Bradley then, unprompted, as this, and unprompted is important. It started when she left the DA's office and was a judge in South Fulton. It goes on, Ms. Merchant says, she liked it started when she left the DA's office with the appropriate emoji or whatever one would call it to say it was liked. And then Mr. Bradley say they met at the municipal court CLE conference. Again, unprompted. He's now definitively telling Ms. Merchant when this relationship started. Ms. Merchant says, that's what I figured when he was married. And then Ms. Merchant says, and we're now talking about a couple hours later, she texts and says, upon information and belief, Willis and Wade met while both were serving as magistrate judges and began a romantic relationship at that time. And Mr. Bradley responds, no, municipal court. Thank you. Doesn't say it didn't start then. He doesn't suggest that she's wrong other than magistrate court municipal. Now we have that, and it's in evidence. And what does Bradley do? He knows that he's put himself in a position that if he testifies truthfully on the witness stand, Your Honor is in a position to be able to find, if you choose to, that both Willis and Wade lied. So what does Bradley do? Look, you were an assistant U.S. attorney. You know how this works when you have witnesses in this situation. Mr. Bradley did everything he could possibly do to evade answering questions. No recollection, couldn't remember, it was speculation. Anything he could possibly say that would cause, Your Honor, not to believe that Bradley knew when this relationship started. I suggest they were clear-cut lies, and the truth is in Defense Exhibit 26.
And so if we take that view, that he thoroughly impeached himself, that he did not give truthful conduct, what's left standing? Generally, you would see someone who's impeached, perhaps we have some kind of core that you could point back to and say that's the time he was telling the truth. In these text messages, Is it ever definitively shown how he knew this and that he actually did know it, other than just a assertion outright? Absolutely. Usually, if a state has a witness that goes sideways, they've got him locked in. They've sat down with a detective, got a full statement. We don't have that here.
But what you have is a text message, which is a prior statement of Bradley that he did on his own, that was not given to him by someone else. The only thing that the court has just noted is, how do we know he wasn't speculating? Because you don't have to accept the fact that he wasn't speculating. The cases that I provided, I think by email yesterday, the first dealing with that, you can disbelieve that testimony and draw a negative inference. That's the Ferguson case. On Lee, the other case, you can simply take the prior inconsistent statement as substantive evidence. It has the same value. And that's what I'm asking you to do, to take what was the unprompted statement in Defense Exhibit 26 of Bradley and take that on its face value, that is an indication that Bradley in fact knew and had said he did. If you accept that, you have to have concerns about the truthfulness of Willis and Wade on the timing issue.
And I don't know if this is something maybe one of your co-counsel were going to address as well. We heard about kind of the law that applies, how we're outside kind of the orbit of the core of cases we're used to dealing with here, where it deals with side switching or where someone is in the relationship, the client relationship. The proposition you're putting forward now is that if a representative of the state, a lead prosecutor, the district attorney themselves, says something that's untruthful on the record, that is something that immediately has to be proactively policed by the trial court. Is basically what I'm getting at is, where in the law do we find the remedy to an untruthful statement? Generally, we send you down the street to the bar, right?
And that's why I gave you the cases of Registe and Edwards yesterday. While those aren't prosecutorial cases or dealing with prosecutors, they deal with counsel. And in both those cases, the trial judge found ethical violations on the part of defense counsel, or potential ethical violations. Went through the ethical violations and said, based on that, you're disqualified. You cannot be the attorney of record in this case. What's good for the goose is good for the gander. If defense counsel can be kicked off of a case because of ethical violations, I suggest the same thing can happen for prosecutors when the ethical violations deal with truthfulness, candor to the court, extrajudicial statements. Those are the things that this court can rely upon and say, based on those, again, I find an appearance of impropriety.
Where would be the limiting principle? The district attorney signs every indictment assigned to this courtroom.
No,
Does that mean she's off every case?
No, it would be when the...
If I found that she's untruthful, is that what you're kind of suggesting, though?
You don't have to find, again, I'm not saying you have to find she was untruthful or that Wade was untruthful. You don't have to make a finding of fact that they lied. All you have to do is make a finding of fact that you have genuine, legitimate concerns about their credibility, about their truthfulness. And once you find that, then you can apply Registe and Edwards.
Well, but it's the same principle, though. If I have genuine concerns about her truthfulness on a particular occasion, how do those not spill over into every criminal case a district attorney brings?
Well, it's because she testified under oath, and so did Mr. Wade. They didn't have to testify falsely. They could have testified truthfully. They could have indicated that the relationship, the timing was in fact before Mr. Wade was hired. They chose not to. And in that sense, that dishonesty, that constitutes a violation of their ethical responsibilities. This is not signing an indictment. This is not filing a pleading in which both sides have their own positions. This is a requirement that every witness has to tell the truth under oath. And if they don't tell the truth under oath, or there's a significant concern about their credibility, then they're violating their ethical rules. And as anyone will tell you, as Your Honor already knew from when you were a prosecutor, prosecutors are held to a higher standard. They're the ones that are supposed to be seeking justice. They don't have a particular, they're supposed to be disinterested. When you have the lead prosecutor and the DA giving, what I suggest to you is untruthful testimony based on what Yerty has said, based on what Bradley said in his text, based on the whole way it was presented to you. Bradley didn't want to testify. He first came up with his attorney-client privilege thing on that. And Your Honor was, fortunately, went into that. And then when Bradley knew he had to testify about it, you saw what happened. You can draw the inference, as I've suggested on Bradley, that what he said in the text message, Defense Exhibit 26, is true. The relationship, in fact, started prior to November 1st of 2021. That Yerty says that. And now, without getting into any detail, the cell phone records. The cell phone records show that during that period of time from, let's say, April 1 of 2021 to November 30th of 2021, that there was a considerable number of 35 or more occasions where it appeared that, based on the records, that Mr. Wade was down in the area where Miss Willis was staying in Yerty's apartment. But more important is there are 2 occasions, and the state has not challenged those. There are 2 occasions where the records reflect that it appears Mr. Wade spent the night at that apartment. The state may say, we don't accept that, but they didn't challenge it. And even when they brought forth what they brought forth today, Supplemental 2 and 3, they didn't challenge it again. So what does that suggest? That's corroborating evidence of what Yerty had said, of what Bradley said in his text message. It's also impeachment evidence as to what Wade and Willis said about how many times.
Is that a significant, in terms of just the times? Didn't Mr. Wade testify that he was there at least 10 times during that time frame? You've now found 35.
Well, minimum of 35.
Okay.
But never overnight. He said he never spent overnight.
Put that to the side, though, just in terms of the fact that he did say he'd been over there, that he'd visited the place, and I would presume he wasn't obviously keeping a very good accounting of it, but that wasn't something that was entirely denied.
If you're asking me, do we win on the point that he said more than 10 or around 10 and we say 35, do we win on that point?
Sure.
No.
Okay.
It's not determined.
The overnight rate might raise some more concerns. Understood.
Yeah, it does. And that's the reason why we highlighted it in the affidavit of Mr. Middlestadt, because that is suggestive that they were not being honest to the court. So then, how much time have I used? Have I?
I'm letting them use the hook. So, suggestive. Again, raising issues. I'm wondering about burden. Is it we're dealing with a preponderance standard?
We are dealing with a preponderance standard, and it's our burden. Yeah. No question about that.
So does suggestive get us there?
No, but it is corroborating evidence of evidence that we did put up. And that's what the purpose of the cell phone records. They corroborate what Yerty says. They corroborate what Bradley said in Defense Exhibit 26. And they impeach, to that extent, Wade and Willis's testimony. So if you find by a preponderance of the evidence, so I can finish this up, if you find by a preponderance of the evidence that what I call subset of forensic misconduct, ethical violations, has been shown, and that there is a significant and legitimate concern about the truthfulness of Wade and Willis, they're disqualified. Now, obviously, the factual findings are yours, but the law allows you to do that. You don't have to do it through an actual conflict. That's the other side of the equation. And that's what I've argued, and I think that's what Mr. Gibbons can argue.
Before I let you go, though, this is an interesting classification. You're saying forensic conduct isn't just commenting publicly about the case indicating guilt. You're saying forensic conduct is just anything a district attorney says falls into that box?
No, I'm saying that
improper,
that forensic misconduct as a subset of that would include violations, ethical violations, which impact the ability of the defendants to get a fair trial, as well as impact the court's ability to have faith that the prosecutors, these 2 prosecutors, are acting in good faith in their own conduct. Same idea dealing with, as I said, defense counsel in the 2 cases I mentioned. Ethical violations can give rise to disqualification, and I suggest we have that here.
All right. Thank you, Mr. Sato.
Thank you.
Where's the shot clock when you need it?
Right there.
Your Honor, I want to address very directly here. What we have is a systematic, continuous pattern, a calculated plan, evidencing a design to prejudice the defendants in this case, in the minds of the jurors. This is what we have seen. This isn't the problem that the district attorney has. It's not that the district attorney had some sort of brief off-the-cuff statement in an interaction with a reporter like in Williams. That's not what we have here. We have someone who sat down, wrote out her speech, wrote out her plan, who sat down for whether it's 2, 3, or 6 times with the editors of Find Me the Votes and told and got her message out about this case before it was supposed to be tried in this courtroom. And so that is the problem that we have. We have a pattern of forensic misconduct on behalf of Miss Willis.
So, I mean, we have a pattern of public statements being made. I take it you or your team has dived in and read the book. I know she was asked about specific portions in it. The only case that I can find actually talking about when someone crosses the line on public comments is that Williams case, and it talks about there has to be an implication of saying the defendant, a particular defendant, is guilty, and it even denied it, right? So, have you found any case in Georgia where they actually said that a prosecutor had gone too far in their public comments? Does one exist?
Well, number one, thank goodness it doesn't happen often. Sadly, it's already happened here. Now, in Williams, the prosecutor had one response to an inquiry the court found it was improper, but did not have this pattern. Now, it doesn't necessarily mean a comment about the quote guilt or innocence, although that was the pattern in Williams. It's the improper comments by a prosecutor. For example, in Williams, they cite the nature and consequences of forensic misconduct in prosecution of criminal case, a 1955 Columbia Law School article, and how prophetic that was. When Williams cites that case in that law school article, they talk about an awful lot more than simply the comments about specific guilt or references to guilt. What you have here, Your Honor, is a comment, and we can't look at it doesn't apply only if a prosecutor said, "I think the defendant is guilty in my mind." No, it's more pernicious than that. What we have here is someone who sat down and drew up a plan for 2 reasons. And what she did reminds me of what the court in Estes v. Texas talks about, and that is that pretrial can create major problems for a defendant, indeed more harmful than publicity during a trial, for it may set the community opinion as to guilt or innocence. That's what we have here. That's exactly what we have. And the court in Estes talks about the power of the television camera. So what do we have, and what did this prosecutor do? What she chose to do is sort of what was criticized by the Supreme Court in Shepard v. Maxwell. Legal trials are not like elections to be won through the use of meeting halls, the radio, or the newspaper. That's exactly what we have here. What we have is a deflection. What this is all about is more insidious than just making the comments that she's made. It's a deflection. What she chose to do was to say, okay, I have done my best to hide the relationship with Nathan Wade. And Nathan Wade has done his very best by filing false documents in his divorce case to hide his relationship with Miss Willis. Now, and so what did they do? Well, when Miss Merchant filed the motion to disqualify, now the game plan has to change. The game plan I call the deflection begins to take place. The deflection is when the district attorney sat down and wrote out. I'm sure the court has. When you look at that video, it's in evidence of her speech at church. She has written out everything, and she's reading from it. She chooses to deflect. The court asked earlier, wasn't she really responding to the motion that had been filed against her? Would that she had. Because if she had, she would have looked the members of that church in the face and say, there's been an allegation that I had a romantic relationship with Mr. Wade, and ladies and gentlemen of this congregation, it's true. She didn't do that. She chose to deflect and to do two things that are reprehensible for any lawyer, but particularly for a prosecutor. She chose to pull out the race card and the God card. That's what she did, and she wrote it out. She went on to deflect away from the allegations in the Wade motion, and she said, she's saying, why, in her talk, public discussion with God, why are they only attacking one, in reference to Mr. Wade? And then she goes on to say, God, isn't it them playing the race card when they only question one? Now, if she had been truthful with that congregation, truthful with the community, she would have said, I had a relationship with him. Good, bad, forgive me, whatever. That's what she should have said. But she chose to deflect and say, them, the reference to them and the others and they. It's obviously a reference to the motion filed by Ms. Merchant. They choose to go after the black man. And she then goes on, again, deflecting away and deflecting to what I call the third rail in American society, choosing somebody on the other side of being a racist. So-and-so is a racist. They're racist. She was the one playing the race card in a way to try to deflect from her own conduct. She goes on to say in discussions with the Lord, God, is it that some will never see a black man as qualified no matter his achievements? Again, the deflection. What is she saying? The listener is not necessarily in that audience in that church. The listener is at Fulton County. The potential jurors who will come into a courtroom and say whether or not they can fairly judge the evidence or judge the defense in this case. She chose to inject race into the minds of the listeners and virtually everybody in this community, and literally everybody in this country has reviewed and analyzed her speech that she made in a premeditated way. And in bringing in not only the race card, but also in bringing in the religious matter, this is exactly what Hammonds v. State in our Supreme Court talks about, condemning as an inflammatory appeal to the jurors' private religious beliefs. Why would she do that? To deflect. But now, not only is she deflecting, but she is then going forward and, in a way, telling the community, telling the congregation that God is on her side, not on the side of these people. God, she said, and when she's talking, and she's saying, God, pray for their souls. I, meaning God, qualified you. I qualified your imperfect, flawed self. I see you in every hour. Do my work. As though she's telling the folks in her very, very, very implicit way, injecting into the minds of the jurors, God wants me to win this case. God wants me to prosecute this case. And why is he going, and why are these others going after the black man? Well, the answer is very simple. As we said in our brief, we didn't mention Ms. Cross, the white female, or Mr. Floyd, the white male, because there was absolutely no evidence, and is no evidence, of a personal romantic relationship with them in which he obtained these benefits. That's the reason why we did not do that. So she goes forward with her with the deflections. That's exactly what she does when she goes forward. And she talks about a planned interviews time and time again with authors of the book, Find Me the Votes, where she's talking about a case that's going to be tried in this courtroom. It's reprehensible.
So in that specific, instance, setting aside the fact that she was willing to go on the record before a case had even reached the jury, what specific statements from that book do you contend cross the line?
Well, for example, she's saying, she goes on to talk about all the calls that she gets from people calling her racial terms. All the calls are racist. What she's trying to do.
On the closing arguments that we're hearing right now about the Fani Willis and Nathan Wade hearings, we're joined by David Gelman, criminal defense attorney and former federal prosecutor. David, thank you so much for joining us. What are we learning in these closing arguments so far?
Well, thank you for having me. Well, we're learning, I think, that the judge really has come to a decision already. It seems like the defense attorneys are really hammering down on what has already been shown to the public, and now they are just getting to the point. The judge did indicate that he could have the decision. I would expect in the upcoming days. They're showing that there have been inconsistencies with what Fani Willis and Nathan Wade have said multiple times. They're talking about not only have they lied on the stand, but that the judge doesn't even need to think that they did lie, but just that there is an appearance of a lie or an appearance of impropriety. And that's all that the law in Georgia needs to have Miss Willis be disqualified. And once that happens, game over.
Yeah, and talk about some of those things. We're hearing about this $9,247 that Willis and Wade cannot account for in their testimony, according to Ashley Merchant's husband, who hasn't appeared so far in this case except for today. Talk about that.
So it's very interesting, because one of the facts that has been brought up is that Fani Willis and Mr. Wade, they went away on vacation multiple times. Now, it's a self-serving interest, if you will, because Fani Willis, her office paid Mr. Wade hundreds of thousands of dollars to represent the state of Georgia in this case. And now Miss Willis and Mr. Wade were in a relationship. Obviously, that is a impropriety in itself. And now if Mr. Wade is paying for Miss Willis on vacation out of funds that Miss Wade or the state of Georgia are paying, and Miss Willis is paying allegedly not a little over $9,000 in cash, and there's no trace of it. How in the right mind, or who is possibly going to believe that she was not enriched by her office or the state of Georgia paying money for this? It doesn't make sense. It is an outright lie, and just by saying this is an ethical violation in itself. Again, the judge is seeing this, and he has a duty really to take her off of the matter, in my opinion, at least.
And David, from what you're hearing, what kind of picture are these closing arguments painting of Nathan Wade's relationship with Fulton County District Attorney Fani Willis?
So, they're showing exactly what they've been testifying about and what they've been hammering for the last couple weeks, that Nathan Wade and Fani Willis have had a relationship not since 2022, which they have said they did, but in fact, it started in 2019. Now, his divorce attorney, Mr. Bradley, he originally texted Ms. Merchant that, yes, they had started their relationship when she was a municipal court prosecutor and, she was on the bench. And then when confronted with that, he said, I don't remember that, or no, I don't think that happened, or maybe it did. He was trying to evade all these questions. He was being impeached. His credibility is pretty much gone now, and he has he's going to have his own ethical issues going forward, I would assume. But Nathan Wade and Fani Willis alone, they have their credibility just by their demeanor, from how they testified, it's damning. It's very, very hurtful, in my opinion. Now, what they have said, they are, number one, they are crossing each other up. They're not believable. The defense attorneys, I think they did a very good job at both disguising and showing them, or pretty much presenting evidence to contradict what they are both saying to each other, showing evidence, and especially the text messages from Nathan Wade's phone, the data warrants showing that he made all these text messages and phone calls in 2019 and 2020 when Mr. Wade said that they were not in a relationship then. These phone records contradict exactly that. So it really goes against everything that both of them have said. Again, they only need to prove, the state really needs to show, or the defense needs to prove that they are there's an appearance of impropriety.
And David, from what you said in the beginning of our conversation, it sounds like you think that the judge is going to rule that there is that impropriety, that Willis could be disqualified. If she's disqualified, what would that mean for Trump's Georgia case?
Well, I think it's going to be very good for Trump's Georgia case. Number one, if this does happen, that the case will be postponed for quite a bit. It would definitely be postponed until after the election, which is definitely a good thing for President Trump. But the other thing is, another attorney's office, most likely the Attorney General's office of the state of Georgia, would have to take a look at it, or would be assigned to it. And they would have to go over the whole thing again. There's a lot to this, obviously, and there's a lot that they would present, and they would have to review. And a fresh set of eyes would be the best thing of it. I would, obviously, looking at everything, I don't think there's a lot here. It's definitely not a RICO case. Looking at everything, in my opinion, I would think it would be dismissed. But that obviously is going to be up to the Attorney General's office if, in fact, it is going to them, and if Fani Willis is disqualified from this.
All right, criminal defense attorney and former federal prosecutor David Gelman, thank you so much.
Thank you for having me.
And now we'll tune back in to the hearing here in Fulton County, Georgia.
The day trips that both Wade and Willis admitted to, so that number is likely even higher. We know from the documents that Ms. Willis only paid $1,394 for an airline ticket. We know from Ms. Yurty, who was pretty much uncontested, there was no evidence presented by the state disputing her time frame, that relationship started in 2019. She saw them kissing, she saw them hugging. Now, whether or not they had sex before January of 2022, I do not know. They admitted sometime in early 2022, and I found it curious that they both, Wade and Willis, just went straight to the sex. So maybe that's when they started having sex. I do not know. But the relationship predated that. And their combined and overly suggestive focus on that is a red herring to this court and to the defense, that's what they want you to focus on. They want you to ignore all the evidence that the relationship predated that. The relationship started in 2019. The relationship continued through 2020. The relationship continued through 2021. Looking at the cell phone communications, just in the first 11 months of 2021, over 2,000 calls, almost 9,800 texts. I don't even think love-struck teenagers communicate that much. The November 29th and November 30th escapade. Phone call from Ms. Willis, between Ms. Willis and Mr. Wade, 11:32 that night. Shortly after midnight, the phone starts traveling down from where Mr. Wade lives and ends up where Ms. Willis is staying, and he's there until roughly 4:55 a.m. None of the excuses, none of the explanations that Mr. Wade gave go into the Porsche experience, go into dinner, going to the airport. None of that explains that. I'm pretty sure the Porsche Experience isn't open in the middle of the night. I'm pretty sure that there weren't any restaurants that he drove 30 to 45 minutes to go eat at in the middle of the night right after he talked to Miss Willis. Teenagers have a name for those kind of calls and those kind of escapades. I won't go into it. But the documentary evidence, the objective evidence, undercuts everything that both Wade and Willis said. When you look at Miss Yurdy, again, she unequivocally said that relationship began in 2019. She saw physical evidence of a romantic relationship. Mr. Bradley, in the text messages, which are substantive evidence, said that that relationship began in 2019. Again, his January, temporary amnesia that somehow was triggered temporarily after Gabe Banks called him, we can question that. But we do have statements from him that specifically said that relationship predated Mr. Wade's appointment by Miss Willis. You asked, well, in Mr. Wade, you asked what the materiality would be. How much is enough? Well, clearly 17,000 is enough. But Fulton County has told Mrs. Willis what the materiality is. It's $100 in a year. She twice signed declarations, certifications that she did not receive any gifts. And even under her strained explanation, there were monies, there were gifts, there were dinners, there were excess contributions flowing her way that exceeded $100. Her explanation, well, I just paid it in cash. That just does not stand to reason. It does not hold up to the light of truth. Anyone that has ever been in a money laundering trial, a forfeiture trial, if that's the explanation we give the state, they laugh. Oh, I just gave cash. I have no records for it. I have no source for it. The only thing that she could say that was a source for the money, because at times she said she was down to $500 to $1,000. The only explanation she have is, well, sometimes I go to Publix and I may get an extra $50. That shows up on your debit card or your credit card. Did they bring those records in? No. Did they bring her bank accounts in? No. Did they bring any documentary evidence in? No, they did not. And why is that important, Judge? Yes, the burden is ours. But under OCGA 24-14-22, if a party has evidence in such party's power and within such party's reach, by which he or she may repel a claim, and they had that power, Ms. Willis had that power, Mr. Wade had that power, that they can repel the claim that we have made against them, but they admit to produce it, or if they produce weaker evidence, then you, as the fact finder, Judge, it is in your power to disregard that, and a presumption arises that that documentary evidence that is in their possession that they failed to produce supports our claim. And that is something that the state relies on regularly in criminal trials. And that is something that the court should rely on in this case when formulating its factual findings. And we know that both Mr. Wade and Ms. Willis have some difficulty expressing the truth when it comes to their relationship in these cases. We know Mr. Wade lied in his interrogatories multiple times. We know Ms. Willis falsely certified that she hadn't received any gifts from anybody. And Mr. Wade clearly was a prohibited source. He was someone doing business with Fulton County. Anything over $100 in a year, she had to put down, and she put zero. And it defies imagination that she could somehow forget about all these trips, all these dinners, all these day trips, and not put that money down. You had asked, I think it was Mr. Gillen, did she say in that church speech or anywhere else that the defendants were guilty? And I think she did in that church speech. She said in that church speech, and she was talking about a conversation that she apparently had with God, talking about herself. She said, this leader has a trial conviction rate of 95%. She said, the trial team this leader put together has a conviction rate of 95%. I do not see how anyone, and I think that was purposefully intended by Ms. Willis, I do not see how anyone can listen to those two statements and not take that Ms. Willis is telling everyone in that church and everyone that's going to hear that in the media afterwards that these defendants are guilty. That is what she was saying. She is a prosecutor. She's familiar with the U.S. v. Berger. Every single attorney that's ever been a prosecutor is familiar with the dictates of that U.S. Supreme Court case. That is a foul blow. That is improper, and she violated pretty much every tenet a prosecutor must abide by to seek truth and justice in a particular case. So, Judge, when you're looking at this, the uncontroverted evidence shows that they had a relationship prior. The uncontroverted evidence shows that Mr. Wade lavishly spent on Ms. Willis. The uncontroverted evidence shows that the money that he was spending on Ms. Willis came from this contract that he had. And I'm not just talking about the contract as a special prosecutor, but there's also those other questionable contracts that no matter whom his partner seemed to be, they also got. There is a direct financial benefit that Ms. Willis received from this. And Judge, looking back at what Judge McBurney said, if merely hosting a fundraiser for a political opponent of a putative defendant creates not only the appearance but an actual conflict, then what Ms. Willis has done since then in this case creates an actual conflict. But again, as prior counsel has stated, we only need to show the appearance of a conflict. And we have done that by a preponderance of the evidence. In fact, I believe we've shown an actual conflict. But nonetheless, the result should be that Ms. Willis and her office should be disqualified from this case. We still have a few more minutes. I think Mr. Cromwell may have something to say. Thank you, Your Honor.
Thank you.
Good afternoon, Your Honor. Harry McDougald for Mr. Clark. I'm going to talk further about conflicts, and I'm going to assume the most difficult standard for us to meet, which is actual conflict. But before I begin that, I want to add just a little bit to what has already been said about the standards that apply to prosecutors. Our appellate courts have said often the administration of the law, and especially that of the criminal law, should, like Caesar's wife, be above suspicion and should be free from all temptation, bias, or prejudice so far as it is possible for our courts to accomplish it. The first occurrence of that I can find is Nichols v. State more than 100 years ago, 1915. The most recent, Registe v. State in the Supreme Court in 2010, although they don't refer to Caesar's wife. That requirement is also embedded in the prosecutor's statutory oath, 15-18-2, which requires impartially and without fear or favor discharge my duties as district attorney and take only my lawful compensation, so help me God. The general rule on conflicts of interest for lawyers is in Rule of Professional Conduct 1.7. And we all know, it's all drummed into us, that we cannot have a conflict of interest. And if we do, we have to withdraw or we will be disqualified. The basic idea is that a conflict of interest impairs the lawyer's independent professional judgment. That's the test of a conflict and whether it can be waived and whether it's disqualifying. And that conflict is not just financial. It can be any conflict that impairs your independent professional judgment, and you see that in McLaughlin v. Payne. The court asked what was a personal interest for purposes of disqualification. it's anything that impairs professional judgment. That's reflected in the ABA standards that were quoted by Mr. Merchant, which list the prosecutor's personal, political, financial, professional, business, property, or other interests or relationships. And that's really embedded in the prosecutor's oath to act impartially. And the earlier disqualification order by Judge McBurney was based on political interests, not financial. What my colleagues have described as forensic misconduct is also cognizable as a conflict of interest based on that footnote in the Williams case. The root of all of the problems that we see in this court right now is a conflict of interest arising from their individual personal interests in perpetuating and concealing their relationship. That's the original sin from which all of the other problems flow. There are 6 different actual conflicts of interest in this case, any one of which warrants disqualification, but collectively, practically compelling. First, the financial conflict that's already been covered. Second, the personal ambition, political ambition. Third, there's a dovetailed or complementary pattern of deceit and concealment of the relationship and the money. Fourth, the speech at the church. Fifth, the motion for protective order that the DA filed in Mr. Wade's divorce case. Sixth, the way the state has conducted the defense of this motion to disqualify, especially the hearing. On the financial piece, the court asked for a limiting principle and asked about materiality. The limiting principle is whatever impairs the independent professional judgment of the lawyer. That is applied routinely. We have a county code section that flatly prohibits gifts from contractors, period. We have, by analogy, the federal bribery statute, which has a threshold of $5,000, 18 U.S.C. 666. The court asked about burdens and inferences. The court can draw a negative inference from the state's failure to produce evidence to support the invisible magic cash balancing theory based on State v. Thomas, 311 Georgia 407, particularly footnote 19. As to the timing question that the court asked about, there were 2 contracts for Mr. Wade executed after they acknowledged the relationship began. Each one of them afflicted or conflicted under county and common law. The second conflict is her political ambition, for which he was previously chastised by Judge McBurney. And that's also present in this book. The inside flap of this book says that they were given, quote, exclusive access to thousands of secret documents, emails, text messages, and audio recordings. The court has twice denied defense motions to unseal special purpose grand jury materials. She helped herself to get the glory of this book. I introduced certified copies of a number of county code sections. I'm not going to walk through those, but I'll tell you why they matter. The stack of law from the state constitution down to the county ordinances imposes a regime on the DA under which she has 3 obligations. She has to go to the county commission to get approval to pay him like she did. She cannot accept gifts from a prohibited source. She has to disclose the gifts that she received. She evaded all of those requirements. Section 2-69 of the county code prohibits gifts from prohibited sources, which he was. There's no boyfriend exception. The disclosure forms, the evidence is sufficient for you to find that her disclosure form for 2022 is false and that it is a false writing. That's an actual conflict of interest between her duty, legal duty of disclosure, her legal duty of candor as a prosecutor, and her private and personal interests in concealing the relationship concealing the gifts, and keeping the gravy train rolling for as long as possible. His part in the pattern of concealment is the story you see in many divorce cases. The husband is hiding things from his wife. How much money he's making, the other woman, and what he's spending on the other woman. And he got on that stand, lied in his interrogatories, and then he got on the stand and he lied about lying in the interrogatories. And the lawyers for the DA's office, they just sat there and let him do it. They did nothing to correct obviously perjured testimony. In and of itself, that warrants disqualification of every one of them. The reason they lied and covered it up was to avoid the trouble they're in right now. That served their personal interests to the detriment of their public duties as prosecutors. The speech at the church, I want to focus on why she did that. Mr. Gillen talked about that. She did it to deflect attention from her own misconduct and that of Mr. Wade. She violated her public duty as a prosecutor to serve her personal interests and the personal interests of her boyfriend. That is a disqualifying conflict between her personal interests and her public duty that is actual, operational, and materialized, and it rests on undisputed facts. The next thing that she did that was a disqualifying conflict of interest was the emergency motion for protective order that she filed in the divorce. I filed a certified copy of that as Exhibit 37. She sought a protective order under the Apex Doctrine on the grounds that she's the DA. The whole filing is expressly predicated on her status as DA. In fact, she never lets you forget it. She says it 27 times in 12 pages. In that filing, speaking as DA, she said, the circumstances, quote, suggest that defendant Joycelyn Wade is using the legal process to harass and embarrass District Attorney Willis, and in doing so is obstructing and interfering with an ongoing criminal investigation. In the prayer for relief on page 11, she asked for 6 months to, quote, complete a review of the filings in the instant case, investigate and depose relevant witnesses with regard to the interference and obstruction this motion contends. There's no sugarcoating it. That's a clear violation of Rule of Professional Conduct 3.4H, which prohibits lawyers from making threats of criminal prosecution to gain advantage in a civil case. She abused her power. She abused her position to threaten her boyfriend's wife with criminal prosecution to gain advantage for herself and her boyfriend in her boyfriend's divorce. She violated her public duties not to make that kind of a threat in order to serve her private personal interests and those of Mr. Wade. Another actual operational conflict. The last category is the conduct of the defense of this hearing. There were a lot of objections made based on attorney-client privilege during Mr. Bradley's testimony. Most of those objections were made by the state. But the privilege being asserted does not belong to the state. It belongs to Mr. Wade. That shows that the DA's office is serving the personal interests of the DA and Mr. Wade in carrying out further concealment and cover-up of their relationship, and not the cause of justice they are sworn to serve. That is a conflict of interest. It's a continuation of the wrongful pattern of concealment and cover-up that they've engaged in since the beginning. But now they've enlisted the entire office in the enterprise. In the written response to the motion to disqualify, they said this, and I quote, "Should be absolutely clear, there is no evidence that D.A. Willis derived any financial benefit from Mr. Wade." That's on page 15. Flat out false. 10 lawyers in this case put their name on that, starting with the DA. So throw another log on the bonfire of conflicts of interest. The problem here is the DA cannot distinguish between her personal interests and ambitions on the one hand and her public duties as a prosecutor on the other, and apparently neither can anyone else in their office. Of the 6 conflicts I've identified, only one is subject to a conflict in the evidence. This is a case study in what happens when you operate under a conflict of interest. It's put an irreparable stain on the case. Think of the message that would be sent if they were not disqualified. If this is tolerated, we'll get more of it. This office is a global laughingstock because of their conduct. They should be disqualified and the case should be dismissed.
Your Honor, there's not much oxygen left in the room. We delineated the times based on the whole presentation. Would Your Honor consider some time for us in rebuttal?
No.
Okay, well then, could I reserve what I had, 5 minutes for
Sure,
rebuttal?
that's fine.
All right, thank you, Your Honor.
All right, let's take a quick 5, and we'll be back at 2:40-ish to hear from the state. Thank you.
All right, we are watching the closing arguments in the hearings surrounding Fani Willis's relationship with Nathan Wade. Fani Willis is the district attorney for Fulton County, Georgia. She's the person who brought the election interference case against Donald Trump there in Georgia. She's said to have an improper relationship with the special prosecutor in the case, and we're watching the closing arguments for that hearing, like I mentioned. Arlene, from what we've just been seeing since we last spoke, what's most notable to you here?
Well, I think it's notable that the defense is really hammering home that what has happened here is showing an appearance of impropriety, because I think it's the other side's going to argue that they haven't really shown a clear conflict of interest. And so their argument is, well, we don't have to show a specific clear conflict. All we have to show is that there is an appearance of one. And based on all the things that have happened here, including, both Nathan Wade and Fani Willis committing perjury and the ethical violations that are probably going to come down against them, it's clear to them, and it should be clear to the judge that they should be disqualified.
Yeah, and then we also heard from one of the defense lawyers saying, Harry McDougall, the last one, saying it wasn't just an appearance of conflict of interest. He laid out some specific 6, what he called actual conflicts of interest, from financial to personal and political gain, deceit and concealment, and pretty cogent words there right at the end, damning the whole office. We do know that it's possible that the whole office could face consequences for this. What would that look like?
Well, if the judge determines that Fani Willis should be disqualified, my understanding is that the whole entire office would be disqualified from this case, and then it would go to another DA at some point in time, if at all.
And as we heard earlier, actually, from a couple of the defense lawyers before McDougall, if that does happen, that would require a whole new review, obviously, from the beginning of the case. And that prosecutor may just decide that there aren't enough merits and drop the case entirely. We heard also from our guest earlier today who spoke with Chris, saying, David Gelman, saying that he thought that this was not a RICO case, which is the basis of the whole case.
Yeah, I mean, there have been a lot of different attorneys and legal analysts who have been saying that it wasn't really necessary for her to bring this big, giant case that's going to take hours and hours and hours of time to work on, which goes to the point of the financial benefit that she and Nathan Wade are receiving from this. One defense attorney in Atlanta said that they could have just brought the case against President Trump, which and rather than go through this big, long, drawn-out case and bringing in all these defendants, just to get to President Trump. He said they could have just brought it against him.
One thing that's been pointed out, and we talked about this a couple of weeks ago when we were talking about this hearing then, Willis has been disqualified in this case by an earlier judge who was overseeing this case, from investigating an alternate elector. She appeared at a fundraiser event for his political rival. What do you know about that previous disqualification?
Well, as far as I know, that was determined to be a clear conflict of interest, but there was some kind of a footnote that judge put into his opinion that raised this issue of an appearance. This is why they're talking a lot about an appearance of impropriety. And I think, a lot of the arguments I heard is that in Georgia, you have to show a clear conflict of interest. And this is something that Fani Willis argued in her response, that, there's no clear conflict of interest here. I can still, prosecute this case regardless of whether I'm in a relationship with someone or not. But apparently there is some language that was put into one of the judges, this judge in particular who disqualified her in that matter, that said that there was a high appearance of impropriety. So I think what they're trying to prove here today is that there's also a very high appearance of impropriety in this case, and they're laying it all out, right? All the 6 conflicts, and they're saying even if you don't pick one of these conflicts, all of them together shows, a really clear appearance of impropriety.
I just want to bring something else in here, which is that actually there's a new state commission with the power, there's a new state commission that has the power to remove prosecutors. And that's from the Georgia Senate. So the Georgia Senate itself has opened an investigation apparently into.
Yeah, there are actually several investigations going on simultaneously against Fani Willis. There's the Ethics Commission that has several complaints that have been coming across their desk, and they're going to have a hearing on March 7th. And then the Senate committee actually created this special committee to investigate her. And yes, they have the power to remove her from this position.
And Arlene, it looks like we're going to get back into this hearing soon. They're taking a break. The judge said it would be a 5-minute break. We'll see how long it actually takes. But what do you think what can we expect to see next in these closing arguments?
Well, now the state's going to stand up and give their closing arguments. They're going to say there's no case here. You haven't proven that there was a conflict of interest. Yes, she had a relationship, but it didn't hurt the case itself. They're going to talk about the church speech and how she's allowed to say the things that she said there, and that she didn't directly, hurt any of the defendants or prejudice them by what she said in the church speech. I mean, everything they're going to say is going to counter what we just heard from the defense.
And how can you prove that kind of thing? We heard from the defense lawyers what she said, and that they thought it implied a damning judgment from Fani Willis on Trump, and that she had already concluded, and she was trying to sway their minds in terms of race and religion and issues that are dear to them. Mm-hmm. How can the defense prove that didn't affect this group of people?
Well, they can raise the doubt in the judge's mind, right? This is by a preponderance of the evidence. So they can't directly prove it, but they can raise it to the judge, and the judge will have to consider that, and he has to be able to weigh the different things. I mean, he's the one that's going to make the ultimate decision. He has to look at all of the facts that have been presented to him and think about what makes sense. What's credible here? Who's telling the truth? Is this true that she's paid everything in cash? Does that make sense? He's got to weigh, and then he's got to look at the law. What happened in the past in previous cases? What did judges do then? What were the facts in other cases? And how are they similar to the facts in this case? So he's got a big job ahead of him in deciding this.
And for all the talk about demeanor and the importance of demeanor, we've heard about that already multiple times, even just today. What do you think about the judge's demeanor and how this looks like it's panning out, at least at the moment, for him?
So the judge is doing his job, right? He's asking the hard questions.
Sorry to interrupt, Arlene.
Sure.
We're getting the word that they're back on to the final closing arguments here. Let's tune back into the hearing.
In which defense counsel claimed the evidence would show. And I would strongly bring to the court's attention that the claims that were made were material misrepresentations. And what I will say to the court, and why I say that to the court, is because the representations that were made by counsel was that Miss Daisha Young, Miss Sonia Allen, Mr. Dexter Bonds, Investigator Hill, Investigator Green, investigator Ricks. All of these people would be called, and Mr. Bradley would be able to impeach their knowledge by saying that he specifically in his presence or to him said that Miss Willis and Mr. Wade were in a romantic relationship, and that Miss Willis and Mr. Wade were cohabitating, that they all knew that. And I would submit to the court, we didn't hear from any of those individuals. Mr. Bradley impeached no one. And I say no one because he did not impeach Mr. Wade. In order to properly impeach a witness, you have to confront the witness with the specific statements. Mr. Wade, and you can look back at the YouTube of the entire hearings of the last couple days, Mr. Wade wasn't once confronted with a statement that he claimed or said, or that is claimed that he said to Mr. Bradley. The way you properly impeach somebody, you have to confront the witness. Here would be Mr. Wade, and once he makes a statement that you believe to be inconsistent, and you have a witness who can prove that inconsistency, that's when you call that witness. And when Mr. Wade was on the stand, not once was he asked, did you tell Mr. Bradley this in a confidential conversation in your conference room that was not covered under attorney-client privilege? That was not asked. The specifics of that conversation was not asked. So any testimony that Mr. Bradley testified to is impermissible. It is improper impeachment because they did not confront Mr. Wade with it. So that's where the state would begin with the comments that Mr. Merchant made about me referencing his wife as lying. I never called Ms. Merchant a liar. I never used those words. I don't know why she made the material misrepresentations. It could be because Mr. Bradley lied to her. I don't know the reason. So, but I can submit to the court that those were material misrepresentations that were made to this court on the day a few Mondays ago, as everyone was arguing the motions to quash certain subpoenas. I'd also bring to the court's attention that during that motion to quash subpoenas, certain subpoenas, Ms. Yurdy's attorney appeared, Mr. Partridge, and he made very clear on that Zoom that Ms. Yurdy had absolutely no knowledge of a romantic relationship and absolutely no knowledge of cohabitation. Those were the specific references that he made. So what I would submit to the court is those are considered adoptive omissions that his client has made based on the statements he made because of the representations she made to him. So, and I know that sounds convoluted, but what I would say to the court is Ms. Yurdy told Mr. Partridge, because Mr. Partridge told the court that she had absolutely no information about a romantic relationship, and she had absolutely no information as in regards to...
So, but wait, are you making an argument I should make inferences based... Now, these would be attorney-client privileges, or communications then. She's communicating with Mr. Partridge about what her upcoming testimony is. That's why she's hired him, and you're telling me I should infer things based on her communications to him?
Absolutely, because they're not attorney-client communications anymore when he discloses them to the court and everybody else as they watch the Zoom and attend the hearing. The difference is there was no request to go in camera. There was no request to go or to have a private conversation with you as was done with Mr. Bradley. That would have been the proper procedure. So yes, I'm asking you to infer that 100%. I'm asking you to infer that her testimony was at best inconsistent. Because the testimony of Ms. Yurdy, when she testified, was vague, very little description. When asked in a very leading manner, is it true or do you know that Ms. Willis and Mr. Wade were in a relationship from 2019 into the time you were you were forced to resign from the district attorney's office in March of 2022? She said yes. And then further, when pressed by Mr. Sadow, he talks about why she believed they were in a relationship. And what was interesting from Ms. Yurdy's testimony that they were pretty close friends up until she left the DA's office, that she asserted to the court that on a yearly basis, Ms. Willis said, I'm in a relationship with Mr. Wade in 2019. Oh, by the way, I want to tell you again in 2020, because we're in a new year, I'm still in a relationship with Mr. Wade. And again, in 2021, the assertion is Ms. Willis then went back to Ms. Yurty and confirmed, hey, I just want to reconfirm me and Mr. Wade are still in a relationship. It's absurd. It's absolutely absurd. More importantly, when Mr. Sadow asked her about why she believed that they were in a romantic relationship based on her own observations, she said something. He actually asked her, did you see him kissing or hugging? She said yes, but there was no description or qualification about when it occurred, what she actually saw, was it a kiss on the cheek, things of that nature. So I would ask you to frame her testimony from that standpoint when you're addressing her credibility, as the court is going to do with each and every witness that you heard during the testimony of all the witnesses during the hearing. I'm going to see if my screen will share. Now, I want to talk a little bit about the standard and the burden here in this instance as it relates to defense counsel and the claims that they have made in the motion to disqualify. And as I was doing a whole lot of research, I came upon this law review article from Cornell scholarship reading or publication. And they made very clear that courts have been relatively reluctant to exercise their power to disqualify prosecutors for any reason. And that goes along with the standard. What the state would submit to the court is that the defense has to show an actual conflict. And in this instance, they have to show the actual conflict would be that Ms. Willis received a financial benefit or gain and did it got it based upon the outcome of the case. It doesn't make any sense. It makes absolutely no sense. And during the 3 days of the extensive testimony of all of the witnesses and the prolonged examinations of the witnesses by multiple the defense counsel, they still got nowhere. We're in the same position we were in on Monday. The same assertions that were made on Monday have no answers today as we're before Your Honor. They were not able to provide any evidence as to, or to the contrary, of Ms. Willis and Ms. Wade's assertions of when their relationship began. There's absolutely no evidence that contradicts that the relationship did not begin later than or around March of 2022, Your Honor. I'd further submit to the court, because of this failure, that their assertion or their request that, one, the indictment be dismissed. There's absolutely no evidence that the defendants in this case, their due process rights, have been harmed in absolutely any way. There was zero evidence. Not a single shred of evidence was produced through any of the exhibits or the witness testimony showing how their constitutional rights, their due process rights were at all affected by the relationship that began in March of 2022 with Ms. Willis and Mr. Wade. And because of that, the motion to disqualify should be denied. And Ms. Willis, as the district attorney of Fulton County, and Mr. Wade, as the special prosecutor assigned to this case, should be allowed to remain on this case and continue to prosecute the case to the end, Your Honor, until the trial is set by the court and is to begin. Now, the issues, obviously, you've heard a lot from defense counsel as to what the issues are for you to, I guess, determine. And here it would be the state's contention is that you must find that there's an actual conflict if you were or are to come to the conclusion that you should disqualify Ms. Willis and the District Attorney's Office. And looking at what
I think you're talking about, is this Ventura?
it's McGlynn v. State, McGlynn v. State, 342 Georgia Appeal 170. It's a 2017 case. In that case, as it talks about the standard of proof that the defense, or the burden that the defense must show and go to show an actual conflict, is they say it's a high standard of proof, which is definitely not a preponderance of the evidence, which is a much lower burden for any party who's trying to meet that standard of preponderance. But it's clear that the standard is that is a high standard of proof for both when determining whether there's an actual conflict and when there's forensic misconduct that is found, Your Honor. And I want to go through some of the cases that defense counsel has referenced, as they argued here today and in their filings. And I guess the bright line standard, or the standard and the grounds for which disqualification is appropriate for Your Honor to be determining in all of the cases as it relates to disqualifying the elected district attorney, is you either find that there's a conflict of interest or that there's been some sort of forensic misconduct. Those are, I guess, the two areas that, Your Honor, that is in your purview when you are looking to resolve an issue regarding disqualification. Now, in a recent case, Lee v. State, which is 224 Georgia, Lexus 31. It's a February of 2024 case here out of our appellate courts. And in that case, Justice Pinson wrote that a trial court did not abuse its discretion by failing to disqualify an assistant district attorney absent an actual conflict of interest. And that is the case that was ruled on by the Georgia Court of Appeals about a month ago, Your Honor. Now, the cases in which defense counsel have relied on in their brief.
And we are watching live coverage of the closing arguments in the Fani Willis and Nathan Wade misconduct hearing in the Georgia trial against former President Trump. We will be right back shortly, so stay tuned for this short break.
My dad's name was David. He always talked about getting life insurance, and now it's too late.
No one was expecting my husband Dave to suffer from a heart attack. We didn't have life insurance. We thought we had more time.
Don't be Dave, and don't wait until it's too late to get the life insurance coverage you need. And if you don't have enough insurance to cover funeral costs, credit card debt, and other expenses, your family is going to get stuck with the bill. Call now to get affordable life insurance.
Just call 800-494-1562.
If you're over 50, you can't be turned down for this insurance, regardless of your health. Plus, there's no medical exam, no health questions. Your rate will never go up. Your coverage will never go down. And rates start as low as $5 a week. Remember, don't be Dave. Call now.
Call now. 800-494-1562.
Hello, I'm Mike Lindell, and I'm here to tell you about my new product from MyPillow. Towels that actually work. Watch this absorbency test. Here's another towel that we randomly went out and bought. Here's one of my towels with the nice design. I don't know if you can see this, but you could line a swimming pool with this. I mean, this is crazy. Get rid of it. Towels that actually work. What a concept. I'm interrupting this commercial to let you know you can get our 6-piece My Towels, regular $69.98, now only $29.98. Or you can save 25% on our brand new kitchen towels, made with the same technology as our famous My Towels. Also, we have bath sheets, bath towels, washcloths, hand towels, and so much more. And the best part, with your promo code, your entire order ships absolutely free. So go to mypillow.com or call the number on your screen. Use that promo code to get deep discounts on all my towels. And for a limited time, your order ships absolutely free.
When I drink it, the first thing was I feel the warmth in my tummy. It's kind of like gently radiating out, a kind of a very comforting warmth. And it was really good, actually. I felt much better. I did feel, actually, an effect. And I find that it is actually better when I take it regularly.
It's actually steamed and dried 9 times. And so it's really, the essence is really extracted.
Then a second time, I tried it really like on an empty stomach and just 2 teaspoons of it, and over a few times. And wow, that was a big difference, because suddenly I could feel, wow, I was very good energized. I didn't have to eat. I could work outside in the garden for a couple of hours, and I still felt very well. And I was impressed by that. So I think it's a good product.
Welcome back, and thanks for tuning in for NTD's special live coverage of the Trump trials in Georgia. I have my co-host and colleague Jack Bradley here joining us now. We've been hearing attorneys' final statements in Fulton County District Attorney Fani Willis's disqualification hearing.
And the judge has been hearing arguments on whether Willis and her team should be disqualified from the high-profile election case against former President Trump. Over the next few hours, we'll continue to bring you live footage of the Fulton County Courthouse in-house analysis from our own legal correspondent, Arlene Richards here, and our top legal minds as well, breaking down what it all means.
So let's tune.
One of the cases that was referenced here earlier and is also referenced in some of the briefing by defense counsel is the Regestive v. State, which is 287 Georgia 542, and all of the cases that fall under this, what I would call category, is about a attorney who formerly prosecuted a defendant in, I guess, the same type of case or the same case or similar charges, and that would be why the courts the courts found that disqualification would be necessary because of the relationship that existed between the former client and the now person who's being prosecuted, Your Honor. The next series of slides just goes through what has been addressed as it relates to the standard that is required when dealing with the issue of disqualification, and the state would contend and submit to the court that the defense must show an actual conflict in order to have the district attorney disqualified, and that actual conflict has to be in the form of showing that Ms. Willis, in this instance, received a financial benefit or gain in relation to the outcome of the case. Like many of the cases that involve personal interest, Your Honor, it's all based on a contingency fee, where how much they're paid, or a bonus, for example, is dependent upon the outcome of the case. That's how one is to show that there's a personal interest in the case. We have none of that here. And I would submit to the court, we have absolutely no evidence that Ms. Willis received any financial gain or benefit. The testimony was that Ms. Willis paid all of the money back in cash as related to the trips, and if didn't pay back in cash, it was
all right. Let me explore this one a little bit. So, in addition to you're saying it's only an actual conflict, are you also saying that it's only if a financial interest is affecting the final result, the outcome? That's the only one we should be worried about, or is it that the prosecution as a whole is what we should be looking at in terms of a stake? So, what I'm thinking of, I'm just going to try and come up with some hypos here. What if ADAs are given a bonus for every motion to suppress they win, $1,000 per Fourth Amendment claim they win? Well, now they've got an incentive. If one of their officers is lying, not to tell you about it because they want to win that motion to suppress. But maybe that doesn't affect the outcome because you can win a motion to suppress or lose it, and that doesn't decide whether, it's going to be a guilty or not guilty verdict. But doesn't that affect the prosecution of the case, if not the outcome?
Yes, I would definitely agree that that would be an instance where disqualification would be necessary and appropriate because it's a situation that involves a contingency fee, and I would submit to the court that it actually does end up affecting.
It could, based on how important the motion to suppress is, right? But if it's some immaterial, I don't know. But I guess, so you're saying it's maybe not so much just whether it's a guilty or not guilty dismissal, null pros at the end of the day. It is actually the conduct of the prosecution that should be looked at throughout the course of the prosecution.
Correct, as it relates to how it affects the prosecution, which I would submit to the court ultimately is going to affect the end outcome of the case. If you have a contingency fee based.
And now for analysis, we're joined live by Jonathan Houlihan, General Counsel and Director of Legal Operations at Citizens Defending Freedom. Welcome, Jonathan. Great to have you on with us. Now, we've been watching so much unfold, even just today. There's a lot coming out in these closing arguments. What's your take of the latest that we're hearing?
Well, thank you, first of all, for having me on. Happy Friday. I think the defense counsel has done a really great job of laying out the motion to dismiss and disqualify Nathan Wade and District Attorney Willis. Especially, they laid out the concerns about the truthfulness and veracity and the appearance of misconduct. I mean, the entire United States, or at least I think a lot of folks have been watching this case in utter dismay. It reminds us of true courtroom drama, like an episode of Suits. And it's some of the evidence we've heard has been shocking, especially as an elected official, that, the relationships, the trips, all of these things point to ethical misconduct. And it's enough to disqualify under Georgia law. What we saw with the testimony from Bradley and as laid out by the defense counsel, there was an appearance of a relationship or an actual relationship while the district attorney was approving contracts of taxpayer money up to $700,000. I think Americans expect their legal system to be transparent and they expect justice. And in these circumstances, it's clear to anybody paying attention that they haven't been transparent with the rule of law here.
And we heard the judge earlier questioning what could be the limiting principle here for the consequences. How far do you expect this to stretch into consequences for Fani Willis, Nathan Wade, potentially the whole office of the DA?
Well, frankly, I'm shocked. As a former prosecutor, I'm shocked she didn't voluntarily remove herself or Mr. Wade just from the appearance of impropriety. So I think the consequences are larger than just the case for Ms. Willis and Mr. Wade. They have whether or not they get disqualified from the case and somebody else picks it up. That's one thing, but she's got to worry about. Georgia has a new law in the books with the Prosecuting Attorneys Qualifications Commission. She's got to face potential ethics complaints if she lied under oath, and also bar complaints. As a matter of fact, Citizens Defending Freedom, we filed, our state director and our attorney in Georgia, Alex Johnson, filed an ethics complaint with the Fulton County Ethics Board and with the Prosecuting Attorneys Qualifications Commission, just based on the evidence presented in the case and based on the sworn testimony and the affidavit. So I think this has larger repercussions of just the criminal case at bar for her personally. And I think that is another reason they're fighting so hard, because it could have long-term professional ramifications for Ms. Willis and Mr. Wade.
And yet you heard just now one of Fani Willis's attorneys saying that they thought there was no evidence to suggest actual conflict of interest, and that actual conflict of interest is what's required for these kinds of consequences to come about for Fani Willis. What do you say to that?
Well, they're laying out different standards, and I think they did Judge McAfee's really pulled the strings on a lot of this and gotten some of the case law. There is a different standard on the criminal side as far as disqualifying versus just a pure ethical conflict of interest. I think the record is clear. There's been a conflict of interest. If you look at the contracts that Mr. Wade signed as providing professional services, he signed 3 or 4 of them, I believe. And even let's say, for argument's sake, we believe what Mr. Wade and Ms. Willis said, that the relationship didn't start until after he was brought on or shortly thereafter. Well, they still agreed to a series of contracts, different agreements after the conflict of interest started, where he signed a contract knowingly, intentionally. Some of those contractual authorities don't lie squarely with the purview of Ms. Willis. They've got to go through the Board of Commissioners. So there's certainly ethics issues to consider. And those standards, they're slightly different, but I think Judge McAfee's got to really get into the case law and really make a determination if that forensic misconduct was enough to disqualify her on the criminal side.
For sure, and we may hear about that soon. It's looking like it could come in the next few days, but we'll have to wait and see. Now, just finally, Jonathan, I wanted to turn to Trump's classified documents case, which is also happening right now. The trial is happening today, and Trump is down there. The judge is considering whether to prolong the start date of the trial. How could that impact Trump, and why do you think Trump has wanted to suggest a new trial date of August 12th?
Well, certainly the Department of Justice, within their guidelines, their prosecuting guidelines, they strive, or at least they have in the past, to really avoid any kind of cases that would appear that they would interfere with an election. I mean, they cited that as a reason for Hillary Clinton in the past. They really try to avoid this appearance of interfering with an election. It gets into all sorts of issues with separation of powers and whatnot. So I think that's the interest of the Trump legal team, stretching that out, getting it as close as they can to that 60 days so they can kind of point to those internal mechanisms that Department of Justice has, those guidelines that they use.
Right. Okay. Great to hear your thoughts on this. Thank you so much. Jonathan Houlihan, General Counsel and Director of Legal Operations at Citizens Defending Freedom. Great to speak with you.
Thank you so much. Have a wonderful day.
And you. And back to the hearing. We are tuned in to our special live coverage of the Trump trials. There are two hearings happening today, one in Florida and one in Georgia. This one that we're covering today on our program are the closing arguments in the Fani Willis, Nathan Wade misconduct trial. That, of course, relates back to the Georgia election case that Fani Willis and her office has brought against former President Trump. But we do have our panel here today. We have our legal expert, Arlene Richards. So let's pan out and hear a little from Arlene about this. And so let's tune back into the hearing.
Not enough for anything to arise to an actual conflict. And what I would submit to the court as well, that goes to the fact that what it has to be shown is an actual conflict. If it's speculation.
Is there any qualifier there, though, that's in a post-conviction context? So we're talking about, competent evidence. We're obviously in a pretrial phase here. I've wondered how much import to give that sentence when we're in a pretrial realm. That's assessing whether to overturn a conviction, and usually that's kind of an entirely different standard where we assess as a totality. Was there a fair trial? Is there harmless error? I know there's no harmless error when it comes to disqualifications, but just a thought, if you have any reactions.
Well, I think what Your Honor said is pretty on point in the sense that if it's found that if the trial court either applied the wrong standard or should have disqualified the district attorney, it leads to an automatic reversal, like you said, and it goes back to the trial court. And I think that is very enlightening in the sense that that's only done if an actual conflict is shown, and the fact that it can't just be theoretical, speculative, or assumptions that would lead to the appearance of impropriety, the appearance of a conflict that would lead to
I guess I'm borrowing kind of from, as we've been doing the other pretrial motions, special demurrers seem to get different treatment pretrial and post-trial. Post-trial, they get more of a pass unless you can show some issues, and I'm wondering if that same principle applies here with disqualification.
Well, and
but I don't have the answer to that.
Well, what I would also say, and I don't remember the exact line, but I know there in Judge McBurney's order, he does address some of the concerns as it relates to the standard as it's applied post-conviction versus pretrial during pretrial issues. And what I would say to the court is that.
So are you citing that in support? Because I didn't think the state was all that pleased with the analysis he applied.
Well, what I'm citing.
Legal analysis, that is.
I'm citing what you specifically referenced as to the standard that is to be applied pre-trial and post-trial, whether it makes a difference. And what I would say to the court is the answer is no, as it relates to the speculative nature of the allegations or the claims made by defense counsel as it relates to whether a conflict actually exists, Your Honor. What I can't do at the moment is point exactly to the page. At the end of the state's argument, I can give you the page number as it relates to Judge McBurney's order.
I think I know what you're talking about, the footnote where he references the appearance standard.
Yes.
All right, I'm looking at it.
Further, in Lamb v. State, 267 Georgia 41, on page 42, it's a 1996 case where the court says, nevertheless, the conflict must be palpable and have a substantial basis in fact. A theoretical or speculative conflict will not impugn a conviction which is supported by competent evidence. Now, I understand as it relates to the post-conviction factor or the status of the case being in post-conviction based on Your Honor's earlier inquiry, but I would submit to the court that as it relates to the issue of disqualification, that the standard is the same whether it's post-conviction or pre-trial. In Bloomfield v. Bornstein, which is 247 Georgia 406, it's a 1981 case. In that case, it says the appellees have not shown us a case where a per se rule was applied to disqualify an attorney on the basis of an appearance of impropriety alone. The Georgia cases cited by the appellee do not stand for the proposition that a trial judge is authorized in Georgia to disqualify an attorney solely on the basis of an appearance of propriety, which further goes to the state's submission to the court that the standard is that an actual conflict must be shown, and that conflict that arises shows that there's a personal stake of the district attorney as it relates to their personal financial gain that's being alleged. So in the case that's been referenced by all parties here today, Whitworth v. State 275 Georgia, Appeal 790, 2005 case. In that case, it says Whitworth's complaints are largely based on speculation and conjecture. Applying any evidence standard to the record, it is clear that the trial court did not abuse its discretion in denying Whitworth's motion to disqualify Morgan based upon his personal interest in his conviction.
Aren't we past the speculation and conjecture aspect of this, though? I mean, the original and the core of the financial allegation was that there is a relationship and that money has changed hands. There's maybe still an open question of where the ledger stands, but I think it was conceded that that balance could run in one way or in the district attorney's favor. Is that contested?
Yes. What's not contested is that a relationship did develop between
and that purchases were made back and forth. That's the state's position.
That is the state's position, but they were made back and forth. The purchases were made back and forth, either to equal the money that was spent by one party or the other, and if that wasn't done, cash was exchanged in order to equal the costs that were paid by either one of the parties.
Right, but that's a facted issue, whether it was split even or whether it goes a little bit one way or another, or whether it's all the way $10,000 one way or another. That's a fact and issue as a result of the hearing, but it's no longer just the theory that money changed hand is no longer speculation or conjecture.
Well, I agree that money actually changed hands is not speculation and conjecture, but whether that money that changed hands had any financial benefit or gain to the district attorney, that is all speculation and conjecture. I would submit to the court. Absolutely all speculation and conjecture to harass and honestly embarrass the district attorney based on some of the questions that were asked that had absolutely nothing to do with the proceedings that we were here. For example, the lien on her alleged house. that was highly irrelevant, had nothing to do with the proceedings and the exchange of money between the district attorney and Mr. Wade. The point of that line of questioning was to, again, embarrass and harass the district attorney in a way that was very public, and in a way that was to impugn her character as it relates to that line of questioning in front of the court, in front of anyone watching the proceedings as it unfolded. And the language in Whitworth, I would again submit to the court, requires that an actual conflict must be shown, which is why the reference to speculation and conjecture is again a reference, because speculation and conjecture leads to or equals an appearance of impropriety, not necessarily an actual conflict, which I submit to the court is what is required based on the case law. So in State v. Sutherland, which is 190 Georgia Appeals 606, it's a 1989 case, and it says, while the prosecuting officers should see that no unfair advantage is taken of the accused, yet he is not a judicial officer. Those who are required to exercise judicial functions in the case are the judge and the jury. The public prosecutor is necessarily a partisan in the case. If we were compelled to proceed with the same circumspection as the judge and jury, there would be an end to the conviction of criminals, which goes to the premise that the appearance of impropriety is to apply to judges, not prosecutors. Because if that standard was to be applied in the manner in which the Sutherland case is referencing, then there would never be a criminal prosecution, because the state is always going to appear biased as it relates to getting justice for the victims or righting the wrong as it relates to the crimes in which the defendant is been indicted or accused of. So I want to move into I guess the evidence that Your Honor saw and heard during the last couple of days, 3 total days of testimony as it relates to the witnesses. You heard from Ms. Yurdy, who the state would contend is a disgruntled former employee. You heard from Terrence Bradley, also someone who is a disgruntled former partner. The text messages in the state's opinion show that he is vengeful. You heard from his own testimony here sitting before the court that all he did was speculate, and any information that he had and garnered and then passed on to Ms. Merchant was mere speculation. I believe he said that over and over again when asked if he had personal knowledge. My recollection is around 15 times he said he had absolutely no personal knowledge of a romantic relationship between the DA and Mr. Wade. You also heard from the special prosecutor, Mr. Wade, a former judge. You heard from the 80th governor of the state of Georgia, Roy Barnes. You heard from the first female elected district attorney of Fulton County, and you heard from her father, who was a 40-plus year practicing attorney in good standing when he left the practice of law. And what I would submit to the court is that Ms. Yurdy's testimony was nothing more than inconsistent at best, based on what I referenced to the court earlier as it relates to the representations that were made by her counsel prior to.
Are those in evidence? Would his responses during a motion to quash, which weren't subject to cross-examination by defense attorneys, weren't even part of the evidentiary record of the hearing? Again, I'm just kind of puzzled by that. You didn't ask the question of Ms. Yurdy, what did you tell your attorney before coming here? And then we could have dealt with privilege issues and whatever else.
I would agree with the court. It's not in evidence, but it was a statement by an officer of this court to the court during a hearing related to her testimony and how we were to proceed with her testimony in this hearing. But it's clear that what was represented as to why she would not be an appropriate person to testify was that she had absolutely no knowledge of the romantic relationship. That was the basis of why her counsel was saying that she shouldn't have to testify, that she shouldn't be compelled
under
by the
that
court.
theory, if accepted, where did the incentive arise between Monday and Thursday for her to completely change things around?
Where did the incentive arise?
So she was fighting so hard to avoid the. If we're going down that road you proposed, she was fighting to have not to come in here and testify at all, and then she comes in here and testifies. Why would she have testified the way she did if she didn't want to testify so strongly? If we're going down this road of trying to just gauge her interests and these kind of things, I don't know if I'm quite following that theory.
And I can appreciate that, but I would say the reason she didn't want to testify, I would submit to the court, is because this is an incredibly public forum where she would have to testify against a former friend and a former boss. And I think the change, I wouldn't qualify it as an incentive. What I would qualify it is ultimately when she was forced to testify, right, a motive and a bias as to why she testified in the manner in which she did. When asked by Ms. Merchant as to the reasons for her leaving, she kind of danced around the issue. And then as Ms. Cross asked her about whether she resigned or forced to leave, she was fired, she came out and said she was given the choice: you can either resign, but either way you're leaving. You're fired, or you can resign in a manner in which, she wouldn't be officially fired, when she's trying to get future employment and things of that nature. So I would submit to the court that there's absolutely no incentive. An incentive is not why Ms. Yurdy's testimony changed, or the state would contend her testimony changed, but it was the reason she testified the way she did was because of her bias towards the DA, which gave her motive to what the state would contend is be less than honest before the court. And I would. But
if we're going to draw inferences based on her fighting the subpoena, why would she have fought it if she had such a bias and wanted to say these untruths?
Because she didn't want to come on national television and have to be exposed to the things that, well, I don't know anybody who wants to testify before a court in a normal trial, a normal proceeding, but one of what I would qualify in this high profile of a nature where everybody would be able to watch and learn what she has to say as it unfolds in the courtroom. And I'd further submit to the court there is reference to she left the DA's office in the text message that were submitted in, I believe, Defense Exhibit 39, that it's because she released confidential information in the DA's office, from the DA's office, that led to her firing, that she wasn't.
And I know I'm just because it's more conversational, which I appreciate. I know I might be getting you off script, so I don't want to use up all your time if you need to get through some other things.
Next, Terrence Bradley, and I believe the one thing that the state and defense counsel can agree on, that he was less than honest at times during the proceeding and during his testimony. He, when pressed or asked by Mr. Sadow why he was fired, he basically chalked it up to a dispute between partners in a business. But when pressed by Ms. Cross, it was clear that that wasn't the reason. And what I would submit to the court, what has been referenced by defense counsel as baffling as to why the state would go into such a topic area. The state, as all counsel has when appearing before the court, has a duty of candor. And when Ms. Cross knew she was going to have to cross Mr. Bradley, she knew he lied. And she had a duty of candor to the court in the state's opinion to expose that. More importantly, it goes to his credibility and the statements that had been represented by defense counsel that he allegedly had made in the past. So it was important to bring that to the court's attention, because when a witness is testifying, the court is assessing their credibility and determined to whether to believe the veracity of the statements made by the witness or not. So that is the most important factor when determining whether somebody is telling the truth or a lie. Furthermore, he reluctantly, when pressed, finally admitted that he paid off the assault victim. Eventually it started with an escrow account and led to he did pay off the victim in that case. He testified over a span of 3 days, and like I referenced to the court, he must have said 15 times that he had no personal firsthand knowledge as it relates to the relationship between Ms. Willis and Mr. Wade. More importantly, when pressed by counsel, he could not pinpoint a time in which he knew that the relationship occurred. There were many instances in which he described that very well could have fallen within the time frame that was testified and by both Ms. Willis and Mr. Wade as it relates to the relationship beginning or transitioning into dating in March of 2022 and into the end of the relationship in August or the summer of 2023. And as I referenced to the court, the statements that Mr. Bradley made, the state would contend are inadmissible hearsay as it relates to the statements that he was pressed and asked about what Mr. Wade told him, because Mr. Wade was never confronted with those statements. And in order for impeachment to be proper, he must be confronted with the specific statements that are alleged to have been made in order to impeach him. Again, Mr. Bradley had every motive to lie. I believe the text messages are kind of clear, are very clear as it relates to his disdain towards Mr. Wade, which due to the fact that he was expelled or exiled from a thriving law practice, and it was clear that the practice and Mr. Wade sided with the alleged sexual assault victim, which is clear he assaulted her due to the fact that he paid her off. And as I referenced earlier, Ms. Merchant represented to the court that Mr. Bradley had personal firsthand knowledge basically of it all, of everything, and that he would be able to basically be an impeaching machine. I think Your Honor referenced him as the star witness when you were addressing the claims that were made by Ms. Cross in relations to Ms. Merchant's representations to the court. And what I would submit to the court is that all Mr. Bradley's representations as it relates to whether or when the relationship between Ms. Willis and Mr. Wade began, and whether they cohabitated, because that was a promise that was also made, that he would be able to impeach the investigators as it relates to cohabitation, was mere speculation, gossip, and innuendo. And this is, Your Honor.
The impression I got, and we can correct this while we're all here together, is that Mr. Bradley directly overheard a statement from each of these individuals that they could be impeached with. Ms. Merchant, is that accurate?
Directly overheard. Which ones are we talking about?
Well, essentially, that kind of seemed to be all of them. You had said Allen, Bond, Young, and then the investigators, Hill, Green, and Ricks, could all be directly impeached by statements overheard by Mr. Bradley.
Yes.
In reference to your question, the unequivocal answer was yes. And when Your Honor is looking through the text messages, I would submit to the court that the text messages don't even say or indicate what was represented to the court in relation to the good faith basis for this motion to disqualify as it relates to the testimony of and the ability to impeach witnesses through Mr. Bradley. What's been referenced by all counsel is Mr. Bradley's assertion of absolutely as it relates to whether the relationship existed prior to Mr. Wade's hiring. And the question in itself involves speculation because it asks, do you think it started before she hired him? And he says absolutely. He doesn't say he knows. He doesn't provide any context as to how he knows. And in these text messages and through his testimony with the court, the source of his information was unclear. What I would say to the court as to a lot of things, other than the one conversation that allegedly occurred between Mr. Wade and Mr. Bradley, and I would submit to the court that conversation never occurred. That would be the state's contention. And how do we know that? We know that because that conversation was not confronted, or Mr. Wade was not confronted with that conversation. And that is evidence circumstantially, and I'd even say direct, as to that conversation not existing. Because based on the representation made by defense counsel, it would be clear that that would be a conversation that would have been relayed to, because it wasn't privileged, as Your Honor found, that would have been relayed to Ms. Merchant. And if that conversation happened, you better believe that would have been a conversation that defense counsel would have confronted Mr. Wade with and against. And the reason they didn't do that was because it didn't exist. Again, you heard from Mr. John C. Floyd III, the district attorney's father. As Your Honor heard, he was a well-respected member of the legal community for over 40 years. But the importance of his testimony was to provide the court with corroboration as it relates to the years leading up to the relationship that transitioned into dating between the district attorney and Mr. Wade. What he testified to is that he moved into her South Fulton home in 2019. The evidence of his moving into that home at that time was his Georgia driver's license, official government document. He further testified that not only did it wasn't that just Ms. Willis and himself live at the South Fulton home, but that he often would see on numerous occasions the significant other of Ms. Willis that was not Mr. Wade. He referenced that that person had a nickname of Deuce, and that he kept a lot of his belongings in the garage of Ms. Willis. He specifically said he kept a lot of his disc jockey equipment, is how he referred to it when before the court. He made very clear that he had never seen Mr. Wade at the South Fulton home that is owned by Ms. Willis. He made clear that he lived in that home with Ms. Willis and Ms. Willis alone, other than her two daughters who would occasionally visit that home until after February of 2021. But what precipitated the soon move of Ms. Willis to what I would reference as safe houses for her protection was a protest that occurred before her home in February of 2021. He then expressed to the court that Ms. Willis moved in the spring of 2021, and that due to these threats that were taken very seriously, he had only seen his child 13 times. He said, in reference to the questions by defense counsel that were in a, and I'm just going to be straight up with the court, they were trying to make Ms. Willis a liar, what is how I would submit to the court, in the sense that she testified that she was concerned for her safety and her family's safety, which included her father and her daughters, and that Mr. Floyd remaining in that home kind of rebutted all of that, made it so it wasn't true. But he testified that he stayed in the home because it was a home that she had put her blood, sweat, and tears in and was able to buy, and that he stayed in the home because there was constant officer presence. He told the court that he bought extra security equipment. He even went as far to tell the court that he slept in different rooms on different nights because he felt his safety was in such a concern. So I would submit to the court that line of questioning was done in an attempt to discredit Ms. Willis, but failed. Would be how the state would characterize it. Then he testified about the first time that he did meet Mr. Wade, which is in 2023 here at the district attorney's office, and he talked about how he kept cash in his home and why Ms. Willis kept cash in his home. And what the court should take note of is the state didn't ask Mr. Floyd about the cash in his home. That came out through the cross-examination of defense counsel. So there was, I guess, the implication that Mr. Floyd only did so due through his preparation with the state and his hearing and seeing news articles and clips related to the testimony that had occurred prior to him. But I would submit to the court that it's telling that information came out through questions that were asked by defense counsel, which gives credibility to the statements that were made. And he further explained as to why he taught his daughter to keep cash in the home as it relates to financial independence and having a safety net. It was further testified that he had multiple safes and that he gave Ms. Willis his first lockbox, or her first lockbox, for situations as she described when she was testifying. And what I want to make clear is during Ms. Willis's testimony, it was pressed about the cash and where she kept it, and did it follow her, where she laid her head, and things of that nature, trying to further discredit the practice that she had as it relates to keeping cash in her home and why she had the ability to pay cash to Mr. Wade and other people and for other situations. And what the court should take note of is that there was no evidence that controverted that at all. Where was the evidence that controverted Ms. Willis's claim and practice of keeping cash in her home? There was none. In fact, the only evidence was it was substantiated through the testimony of her father, Mr. Floyd. Furthermore, you heard from former Governor Roy Barnes, and his testimony was significant and important because how I would phrase it, Your Honor, is it debunks.
Let me on this point, and I think you might have had a more recent opportunity to review his testimony than I have. You say on the slide that she was the first choice to lead the prosecution. Was that actually his testimony, or was his testimony that he was asked to come aboard? Did he use the words that he was asked to lead?
Yes, it would be that's my recollection, that he was asked to lead the prosecution. He was asked to he was asked to fill the position that Mr. Wade is currently in, which is the lead prosecutor. It was said in that way as well as it relates to the testimony of Mr. Barnes. So I think it would be very clear. My recollection is that he said lead, but what I can submit to the court that I know he also said that he was asked to fill the position that Mr. Wade is currently filling for the state of Georgia, which is the lead prosecutor. At that time,
as special grand jury prosecutor, right?
Yeah, the special, I guess, yeah, as the special prosecutor, lead the investigation, which led to the ultimate prosecution that we're here before Your Honor today. He also indicated that the reason he turned that job down was because it didn't pay enough. He said he had mouths to feed at his law firm, and that he also didn't want to live the rest of his life with bodyguards because he had lived that for the years in which he was the governor of Georgia. Furthermore, he confirmed the qualifications of Mr. Wade, which I still find it quite interesting and confusing as to attacking Mr. Wade's qualifications, in that it's almost as if Mr. Roman's counsel is asking that the state put a prosecutor on the case that she sees to be more qualified to attempt to convict her client. It's an interesting argument, and it's one that makes no sense. Furthermore, if you were to believe the claims and allegations as it relates to Ms. Willis' personal stake in the prosecution, the receiving of financial benefits and gains, then you'd have to believe that she was also dating Roy Barnes, the former governor, and Gabe Banks, in addition to Mr. Wade, if she has this grand plan scheme in order to profit off of the prosecution of this case. Because that's what they're saying. Or they're saying that she telepathically or prophetically was able to know that Mr. Barnes and Mr. Banks would turn down the position so she could then hire Mr. Wade. It's ridiculous. It's absurd, and it's desperate. It's a desperate attempt to remove a prosecutor from a case for absolutely no reason, Your Honor, other than harassment and embarrassment. This slide, and we've been through a lot of the testimony.
And I should be clear there, it was not introduced in evidence that Mr. Banks turned her down, right? How's that part of the record?
Well, I'd ask the court to take judicial notices, has been asked repeatedly.
Unless the district attorney had testified to that. I don't recall offhand.
I will be frank with the court. I don't recall if Ms. Willis testified to that exact fact, but I know that Mr. Banks represented that to the court during Monday's hearing as it relates to the allegations that were made. I understand Your Honor's position as it relates to that.
I'm just trying to make sure we know exactly what is in the evidence and is not, but regardless, I think your point is made.
I think it's an evidence of the record as it relates to, I guess, the issues that led up to the actual hearing of this case. So I understand Your Honor's position, but it did come out during a proceeding that was prior to the actual hearing. This slide is just a chart showing kind of the testimony of both the district attorney, Ms. Willis, and Mr. Wade, as it relates to how they met, how or when Mr. Wade became the special prosecutor, when their relationship evolved into a romantic one, talking about the trips in which they took after their relationship evolved into one that became romantic, and when it ended. And what, again, I would submit to the court is that those facts were consistent, and the only person who contradicted that when the relationship started was Ms. Yurty. And what I would bring to the court's attention is that it was represented to the court that Ms. Yurty was a witness other than Mr. Bradley who could bring to the forefront this issue of cohabitation. And when pressed and when asked about it, Ms. Yurty had absolutely no information as it relates to this alleged cohabitation. It was false. She said she had no information. She was asked about trips. She said she had no information about the trips. Yet, she's such a good friend that Ms. Willis confirmed each year that Mr. Wade and her continue to be in a relationship 2019, 2020, 2021, until their relationship ended due to her forced resignation and it's the splintering of their friendship, Your Honor. I guess several exhibits obviously were tendered in. Most of them were exhibits that came from the sealed divorce of Mr. Wade and Ms. Jocelyn Wade, contracts for legal services, trip itineraries, and the text messages. And I would specifically reference prior to today, the only text messages that were before Your Honor were defense exhibits 26 and 27, which it's the assertion of defense counsel that what those show is that Mr. Bradley had information as it relates to the relationship starting prior to March of 2022, and that's just false. Those text messages do not contain that. It does not pinpoint, just as Mr. Bradley couldn't, when the relationship actually started. And furthermore, you have the testimony and the evidence of the text messages that it was mere speculation. If you, as Your Honor reviews the full chain of text messages, it is clearly Ms. Merchant and Mr. Bradley going through what I can describe as nothing else other than a mere fishing expedition between the two of them at first, because it's asked about certain members of the DA's office who would have information as it relates just specifically, for one, Ms. Young. It is asked whether she would have information, and he had no idea. He said he assumed, he was speculating. And that is the same as each person that was subpoenaed in reference in the text messages. All of that was speculation. And you know it was speculation because not a single one of them testified. That's telling. Because if it wasn't mere speculation, if it wasn't mere gossip, and if it wasn't mere conjecture, each one of those people who were subpoenaed would have been called to testify, like District Attorney Willis was, like Mr. Wade was, in order to be confronted and then impeached by Mr. Bradley. You've heard, obviously, about the phone records, and I have a maybe, because whether it comes into the purview of Your Honor as it relates to the determination Your Honor is to make as it relates to the disqualification of the district attorney. You also have the affidavit from the employee who worked at the winery who confirmed that Ms. Willis did, in fact, pay in cash up to more than $400. And I understand that this is part of the proffer of the state, but it's important because that is a witness who the state didn't go find. That is a witness who went to CNN in order to confirm what Ms. Willis testified to, further giving her statements credibility and credence before the court.
All right, and what you've been watching is, of course, the hearing in Fulton County, Georgia, regarding the misconduct hearing for Fani Willis and Nathan Wade in the trial for against former President Trump that's happening there. And we are cutting now to a commercial. We'll be back shortly.
Did you know the government can essentially rob you in plain sight? Former Fed Chair Alan Greenspan warned, deficit spending is simply a scheme for the confiscation of wealth. But he added, gold stands in the way of this insidious process. Birch Gold Group has helped thousands of Americans diversify their IRA or 401k into gold. To get a free info kit from Birch Gold, text PREPARE to 989898. Again, text PREPARE to 989898 right now.
Tangazo hili linahusu njaa. Tarajia kuona watoto wakiwa na njaa katika maeneo haya. Mambo yalikuwa bora kwa miaka mingi. Tuliweza kupigana na njaa na watoto wachache walikufa. Lakini sasa mambo yamebadilika na kwa mabaya zaidi. Hii ni kwa sababu wakati huu ukame umeangamiza zaidi.
Через війни та конфлікти ми мусимо залишати наші домівки і всі наші речі. Ми навіть не маємо їжі. Тому нам потрібна ваша допомога.
Millions of children are fighting to survive due to inequality, conflict, poverty, and the climate crisis. Save the Children is working alongside communities to provide a better life for children. And there's a way you can help. Please call or go online to give just $10 a month. Only 33 cents a day. We urgently need 1,000 new monthly donors in the next 30 days to help the children we support around the world. You can help provide food, medicine, care, and protection, plus so much more that a child needs, by calling right now and giving just $10 a month.
Ви можете допомогти голодуючим родинам вижити.
All we need are 1,000 monthly donors in the next 30 days. Please call or go online now with your monthly gift of just $10. Thanks to generous government grants, every dollar you give can have up to 10 times the impact. And when you call with your credit card, we will send you this Save the Children tote bag as a thank you for your support.
Toto kote duniani потребують вашої допомоги.
Your small monthly donation of just $10 could be the reason a child in crisis survives. Please call or go online to hungerstopsnow.org to help save lives today.
And we are watching footage from the closing arguments of the Fani Willis, Nathan Wade misconduct hearing in the Georgia election interference case against former President Trump. Let's tune back into that now.
Counsel for defense continued to press District Attorney Willis and Mr. Wade as to whether he had ever been to that South Fulton home. Well, this corroborates that that was not a lie, that he had never been to that home, and it's more than suspect if you've been in a relationship, as they claim, for all this time, but never once went to the house. So I think that's telling. What I would also bring to the court's attention in the state's initial review of the records, that from January of 2021 to March of 2021, those times when Ms. Willis did not live, again, at the Hateville address, she didn't move there until April of 2021, that his handset appears in that area 23 times.
Sure. How do you reconcile that with this testimony that was alluded to, I think, by opposing counsel, the reasons he gave for being in the area?
Well,
would those line up to 23 times? I think, you know, they didn't give it too many reasons for being there, right?
Well, I think that's the point. I would say yes, that is the point. He referenced that that's an area that it was not uncommon for him to be in. And clearly that is the case because Ms. Willis didn't live in that area. So again, it's further corroboration as to what Mr. Wade indicated to the court. And when, I guess after Ms. Willis moved into the condo in April of 2021, they appeared 35 times. Now, I want to make clear to the court, both Ms. Willis and Mr. Wade never denied that he had been to that condo before. The specific testimony that was elicited by Ms. Willis and Mr. Wade was that he had never laid his head, was the direct quote, at that condo, which these records don't prove that he laid his head anywhere. If you were to believe the analysis, or if you were to give credence to what the non-expert says as it relates to Mr. Wade's handset in September and November for the 3 to 4 hours that the phone is alleged to have remained, that doesn't disprove anything that was testified by both Mr. Wade and District Attorney Willis. It was that he visited there. The specific hours of their visits was not something that was pursued during the questioning of both of the parties. So what I would also submit to the court is that if you look at the days as it relates to in September and November, the use, the type of information that is used to make the plots for the longitude and latitude of the handset is data records. It's not voice records. It's not SMS or text messages. It's data records. And it is not uncommon for an expert to testify as it relates specifically to AT&T records that actual data record is unreliable as it relates to the location of the handset due to the type of information that it is, that it's data. It's not the voice and the SMS, which I know, Your Honor, as has been referenced, was a prosecutor not only here in this county, but for the federal government where this kind of information is commonly used. So in the comments that were made by the court, it was clear that you understood and understand the use of cell phone records as it relates to put somebody in an area, and again, not in a specific location. I'd also bring to the court's attention as it relates to the validity of the affidavit and the analysis done by the expert that was hired by Mr. Sadow, is that not once does it reference the fact that AT&T records commonly have duplicate entries within the call detail records. That is something that is commonly seen, and that is something that is seen in these records. And that is something that leads to the incorrect number of times that has been alleged that Ms. Willis and Mr. Wade were in communication through text and voicemail. And I'd also submit to the court that that number doesn't prove anything again, doesn't prove that anybody's in a relationship. It proves that they were in communication with each other. And I think Your Honor can use your own life experience as it relates to people you work with or friends that you're close with and the number of times that you make calls to any of those people. I can submit to the court that I have a friend who I have been friends with for 15 years, and she worked in the office previously with me. And based on our professional relationship and our personal relationship, the friendship that we had had and still have, that we talk 30 times a day. So that doesn't mean we're in a relationship. So the assertion that the number of times that Miss Willis and Mr. Wade have spoken to each other, whether it's through text message or phone, it has no validity as it relates to them being in a relationship. What I would submit to the court is that what was shown through all of the evidence was that there's been a true cost to Miss Willis as it relates to her life, that she had additional expenses that she had to endure because of her position, in the sense that she told the court that she had a mortgage, but on top of that mortgage, that in a house she didn't live in anymore, she had to pay for a safe house, that her home was vandalized, and there were racial epithets and sexual bigotry that were spray painted onto her house. The concern of her safety and her life is something that was testified to, and the fact that this job has led to the isolation and separation of her from her family and friends, which was given credence and were provided by her father, Mr. Floyd, that he had only seen his daughter 13 times since all of these instances occurred. The cruel nature of the statements and the falsehoods that, for example, in these text messages that were purposely.
All right, we've been watching the footage from the Fani Willis and Nathan Wade misconduct hearing in Fulton County, Georgia. What do you guys think? It's been quite an interesting day so far.
Yeah, so far. I mean, now we have the state giving their side of the story, and as I said earlier, they're going to push for this, proving there was a conflict of interest, which is contrary to what the defense is saying, that you only have to show an appearance of impropriety.
Mm-hmm. And in this case, the defense and prosecution the tables have turned here. The prosecution is now on the defense, and why are they claiming? Why is the prosecution here claiming that there has to be an appearance of impropriety is not enough?
Well, they're looking at the case law. Like, both sides look at different case law that works in their favor. So they're pulling out a lot of different case law. They're actually trying to counter the case law that the defense brought out and say, well, they didn't really point out this part of the case, Your Honor, and here it says they have to show a conflict of interest. So both sides are trying to find different sources of legal analysis that is in their favor.
Mm-hmm. And it's interesting, so much attention just now to the phone records, which I believe are not being considered by the judge just yet. He said that he would consider them if he thought at the end of closing arguments that it was necessary, but it still worked its way into their closing arguments.
Yeah, I'm not sure. I thought in the last hearing that the judge said he would allow them to argue about whether or not they should be included as evidence, but I guess they're doing that now in their closings. They're adding that extra argument in there, and the judge is not stopping them, so he's allowing it to go on, but he doesn't have to consider it, I guess, if at the end he decides it's not evidence that should be involved in this case.
And you can see just here what we have in the ahead of us is the here, closing arguments continuing. That's Adam Abate. He's
with the Fulton County DA's office.
Yeah.
And we'll tune into that now.
They're based on the defense counsel's assertions, would have given her the opportunity to certainly find these financial gains that are claimed through the allegations of defense counsel. More importantly, why would Ms. Willis repeatedly ask this court to set a trial date as soon as possible if her motive in prosecuting this case was to continue to financially gain, as alleged, from the prosecution of this case? It doesn't line up. It doesn't make sense. And it doesn't make sense for a reason, because it doesn't exist. More importantly, This office has multiple RICO and as well as large-scale cases like this one, and much larger. And they also have, there's a lot of high-profile prosecutions. If Miss Willis's ultimate goal by hiring Mr. Wade was for her financial benefit, then she would put Mr. Wade on every single one of those cases. So she could certainly revel in the riches and lavish lifestyle that has been referred to by defense counsel, which there's been absolutely no evidence of. The evidence was she stayed at a DoubleTree in Napa, a DoubleTree. I don't know that to be a lavish hotel. Most people, when they go to Napa, if they want to lavishly experience Napa, stay at the Ritz-Carlton, the Four Seasons, things of that nature, not a DoubleTree. So the allegations and assertions that Miss Willis was living the lifestyle of the rich and the famous is a joke. Absolute joke. As it relates to what you heard, and the secondary issue is the forensic misconduct. And for lack of better words, what it has to be shown is that the statements that were made by Miss Willis related to the prosecution of the case and ultimately the guilt or innocence of the defendants. And we have none of those statements. There's been no evidence. Nothing has been provided to your honor as it relates to Ms. Willis's specific statements made about any of the defendants and in relation to the guilt or innocence of any of the defendants. I forget which defense counsel referenced the fact that she said she had a 95% conviction rate. Well, what Ms. Willis's job is to instill confidence in the community as to how well she is doing as it relates to her constitutional duties. And that was exactly what was done when she referenced that she had a 95% conviction rate from the previous.
And now we're joined by Zach Smith, Senior Legal Fellow and Manager at the Heritage Foundation, for his legal analysis. Welcome, Zach. Great to have you with us. To begin with, Willis's attorney, the Fulton County attorney that we've just heard speaking, has said that there's no evidence that anyone's constitutional rights have been affected in the hearing today and all of the evidence that's been presented. What's your response to that?
Well, thank you for having me on this afternoon. Look, this entire thing has been a debacle for Fani Willis and her office. Keep in mind that prosecutors not only have a duty to be impartial, to avoid any conflicts of interest, but they also have a duty to avoid any appearance of not being impartial, any appearance of having conflicts of interest. And I think that's something that's come out over the course of these hearings with all of the motions and other testimony that's been taken, is that certainly Fani Willis has, at a minimum, the appearance of not being impartial, the appearance of potentially having personally benefited from her prosecution of Donald Trump and the other alleged co-conspirators in this case. And I think many people will walk away from these hearings, regardless of the outcome, being very troubled by this prosecution, being very troubled by Willis and Wade's conduct. And they should be troubled by it because it's certainly something we should not expect of any elected official, but particularly from a local elected district attorney.
Certainly, it's a worthwhile question to ask how this could potentially impact people's faith in this case or in these prosecutors, even in the system. But we have heard quite all the way along this idea of the appearance of conflict of interest being of import. But here we heard Abate just now saying that standard only applies to judges, not to prosecutors, because prosecutors, he said, would always appear biased against the person that they're prosecuting. What's your take on that?
Well, look, I think both sides are certainly going to argue their points aggressively and zealously. But keep in mind, the allegations here are that Fani Willis in some way personally benefited from her prosecution of Donald Trump and the others in this case. And this isn't the first time that the appearance of bias or not being impartial has been brought forward. In fact, she was disqualified from prosecuting one of the other individuals who's involved in this entire case. In Fulton County because she attended a political fundraiser shortly after initiating a prosecution against him. The judge said that was inappropriate. It created an appearance of her not being impartial. And so now another district attorney in Georgia has that case and is handling that prosecution. And so this is really a pattern of conduct that we've seen from Willis and Wade. This judge certainly has the unenviable task of sifting through some of the seemingly conflicting testimony, some of the seemingly conflicting evidence in this case, and deciding whether Fani Willis and her office will be disqualified from continuing to prosecute Donald Trump and the others involved.
And we did hear earlier from one of the defendant's lawyers, Harry McDougall, representing Jeffrey Clark in the Georgia case, saying that he believed there were 6 instances of actual conflicts of interest, and he laid those out. But one of them was the importance of the church speech that some of the other lawyers also pointed to and said that that impacted the ability of the defendant to get a fair trial. I just wanted to check in with you. What do you think is the strongest part of the argument on the defense's part, and also what you thought of the argument about the church speech?
Well, look, I think the church speech certainly is very problematic. Not only was Fani Willis essentially trying this case in the public square, she was essentially saying that God was on her side in pursuing this prosecution against Donald Trump and the other defendants in this case. And I suspect if that type of statement were made by a prosecutor about almost any other defendant, that defendant and others would rightly be calling foul. That's not appropriate for a prosecutor to do. And yet, because she said it in the context of this case, really we haven't heard too much about that before it was brought up at the hearing today. But again, if I were Fani Willis or Wade or any of the other attorneys involved in this debacle, I would be worried not only about whether or not I'm disqualified from this case, but also about whether bar disciplinary proceedings will be forthcoming down the road. And I suspect after all of the testimony, after all of the evidence that's been submitted in these hearings, Fani Willis, Wade, and others may potentially be facing bar disciplinary issues as well.
Yeah, and Zach, I want to turn briefly to the other hearing that's happening today in Florida. Of course, that's Trump's classified documents case. And the judge, Eileen Cannon, is currently considering when to start the trial. We have the prosecution asking for a date in July, or Cannon's considering whether to start in July. Trump's team has asked for August. I wonder what the distinction between those two dates may be, and also what the optics might be if this case really does start to bubble up and intensify close to the election in November.
Well, look, I think it's important to place that case within the larger context of all of the other cases that are going on right now involving Donald Trump. You know, there's a case currently pending before the Supreme Court. The Supreme Court's going to hear oral arguments in April over whether or not Donald Trump enjoys immunity from prosecution for certain actions he took while president in the wake of January 6th and in the wake of the 2020 election. And the court will likely decide that case in June or at the very end of June before it begins its summer recess. And so if the trial in this documents case in Florida were to begin on July 8th, as the government has requested, that would likely be in the immediate aftermath of the Supreme Court's decision on the immunity question that Donald Trump has raised in another case. Now, Donald Trump and his legal team, they've actually asked for this Florida case to take place after the November election. But in the alternative, if that cannot be done, they've asked for it to take place in August. But look, there's a lot of legal wrangling happening right now in Trump world. It's unprecedented for a former president to be prosecuted. It's certainly unprecedented for him to be facing 4 different criminal prosecutions, 2 federal and
Absolutely.
2 different state prosecutions. The one in New York with Alvin Bragg is set to begin at the end of March. And so I think we'll see
Absolutely.
a lot more on all of these fronts in the coming weeks and months.
Yeah, there's a lot to watch out for here for sure. Thank you so much. Zach Smith, legal fellow and manager at the Heritage Foundation. Great to hear your analysis.
Thank you for having me on.
And we'll tune back into that. The closing arguments are still going on. We're going to hear further from the Fulton County District Attorney's Office and what they have to say about why they think Fani Willis should not be held in contempt for this.
Why is that?
I'm sorry,
case
say that.
here? Assuming you can impugn someone's character to the degree that it constitutes forensic misconduct. I think that I guess the state's primary position was that they weren't talking about you at the church.
Right. And if you go listen to it and watch it, it starts off by saying, why does Commissioner Bridget Thorne and so many others, and then it refers to they attack him for being black. They attack him, not anyone else, just they attack the black man. They're not talking about Miss Thorne or Marjorie Taylor Greene. They're talking about us. And you know how everybody knows that? Because not a single story from the media reported anything other than Fani Willis accused the defense and defendants of being racist. Now, here's the common sense part of this. If you follow the state's position on forensic misconduct, Fani Willis could all day long talk about race. She could say the defendants, I'm not saying they're guilty or not guilty, but they're racist. They're racist. They're racist. And according to the state's position on forensic misconduct, that wouldn't be a problem. Obviously, that makes no sense whatsoever. The issue here that we've dealt with on forensic misconduct is not simply the church speech. It's why she did it, how she did it, calculated, and all the other things that we talked about with the testimony of Wade and Willis in this case. Let's go to the relationship issues and the cell phones briefly.
All right, we are watching a rebuttal from Sadow. Mr. Sadow, he's the attorney for former President Trump in this Georgia case against him. Let's tune back in. He's only got 5 minutes to give his rebuttal.
Sealed it from all parties, from Daddy. Daddy didn't even know they had a relationship. Suggest that somehow in the beginning of 2021, January to whatever it was into April, that they couldn't have met in Hapeville. They didn't meet anywhere that would allow the public to see them. That's the reason why they were meeting at Yertes, because no one else was ever there. Remember the testimony? Who else was there besides Mr. Wade and Miss Willis? Both of them agreed. No one ever went there except them. They didn't go to where Daddy was in Miss Willis's house because Daddy was there and Daddy would know. No other prosecutors knew. No one knows except who? The one person that knew was Bradley and Yerty. Yerty was the best friend at that time of Miss Willis, and Bradley was the partner of Wade. Now, the only way that the only way that Bradley can walk away from I have very little time, so I'll skip that. Let's go to something. Motive. That's an issue. Whose motive in this case is the strongest? Fani Willis, Nathan Wade. Because if they testify truthfully on every point, what happens if the relationship started before November 1st? They get disqualified. Who has the best motive of anyone to lie? They do. Who has the most at stake to lie? They do. Who wants to stay on this case for whatever the financial reason may be? They do.
And more. Thank you, Mr. Sadow. There it is. All right. Thank you, everybody. I think has been very much made clear by the argument and the made today is that there are several legal issues to sort through, several factual determinations that I have to make, and those aren't ones I can make at this moment. And so I will be taking the time to make sure that I give this case the full consideration it's due. I hope to have an answer for everyone within the next 2 weeks. Until that point, if there are any other issues that come up, counsel can reach out, and we'll have an order posted on the docket. Thank you all. We're off the record.
right, so it looks like it's wrapped up for the day, but a lot has been said. There's, as the judge said, there's a lot of details to pick through. What stood out to you both the most?
Well, to me, it was the arguments from the prosecution and the repetition, and it just seemed that they were a little less confident than the defense here. And I wanted to go over some things that the defense was saying here and the prosecution. Now, in the last rebuttal, we had Sato talking about Willis's comments at the church and how that was supposedly, slandering the defense's arguments and their integrity here. Can you explain a little bit about that, Arlene?
Well, he's saying that they prejudiced the defendants because they said earlier that this was calculated, that she wrote down her speech, and that it wasn't just that she went to church one day and she felt moved to say something. Sometimes people do that, they just get up and they talk, but her whole thing was calculated, and she hadn't even responded to the motion yet, and here she was in the church talking about it. And so, she's influencing the public opinion, by what she's saying. She's using God and the race card to influence maybe potential jurors who may, be jurors in this case by what she's saying. And she's posing herself as the victim. She's the one that they're trying to put on trial when actually she's not on trial, they are. And then this other comment she made about her conviction rate, her 95% conviction rate. And to them, the defense is saying that just says that they're guilty and I'm going to convict them, and you should, and the jury should convict them. So, I mean, these are things that she probably should not have said publicly, and kept it in the motions and on the papers within the courtroom.
And yet she also, co-wrote or ghost wrote or, a book about this that included information about this trial, and which was also brought up. And yet the judge didn't take that as itself anything wrong. He'd said that he didn't see anything particular in that book that contradicted her.
I haven't seen the book, so I don't know what she wrote in it. But I think the law is mainly on the prosecution side in this kinds of situation in terms of what they can say publicly. And as they argued on the prosecution side, they're always going to look as if they're biased because they're always the ones who are going after the criminal. So I think there's a lot of leeway in terms of what prosecutors can and can't say. He mentioned that she didn't say they're guilty. Right? And actually one of the other attorneys on the defense side said, well, she said this. I forget what it was she said, but he said that amounts to saying they're guilty. So it's all on how you interpret the words and,
In paraphrasing, I think it was something like that God had called her to take on this case or something like that, paraphrasing the lawyer and what he had said. But also one of the defense lawyers made an interesting point that these arguments that she was making in the church speech relating to race and religion really are touchstone topics within Georgia itself, and that they would really cut to the heart of people's gut sense of right and wrong, rather than looking at the logical arguments of the case. So that could really target them in that way. Right, because
public opinion is really strong, and what people think and what they feel. Like they say, she's prosecuting the case in the public, basically. Not in the courtroom, and that can have a lot of impact on the jurors that are potentially chosen for this case and how they view it.
Mm-hmm. And Arlene, as for the most serious of alleged offenses here, Willis is facing accusations of perjury, lying to the court. She's facing accusations of benefiting financially from Wade's hiring, and just the conflict of interest here that the prosecution's arguing, the defense rather. What is the strongest argument that the defense has here?
I think the ethical issues are the strongest, the perjury to the court, because as the prosecution is saying, they really haven't proven that she didn't help to pay for these trips. I think that's the weakest part of this, which is why they're saying they haven't shown a conflict of interest. And that's pretty key, because that's a pretty strong allegation that you're benefiting financially from this. And that's not to say that, the appearance of it isn't there. I think, one could argue that it certainly looks that way. And if you put everything together, if she's lying to the court, then maybe she's lying about the cash as well.
And the judge is going to take about 2 weeks, he said, to consider these arguments and then make a decision. How do you think he's leaning here?
I can't tell. I think, like I said earlier, the financial part I don't think is strong for the defense. But on the other hand, as they said, the totalitarian of everything, the lying to the court, which if you believe she's lying, that's a pretty strong accusation. The potential ethical issues, and we have some things that are out there already. People have already filed complaints against her with the Ethics Commission. We have other investigations that are going on, and the judge knows about those things. But, and I think the testimony of Terrence Bradley is really going to be key here. Not so much what he said on the stand, but what he said in the text messages is going to be really key.
Mm-hmm. And as far as the prosecution's point here, Wade's hiring, was he qualified? Was he a right choice to choose here by Willis? What's the prosecution arguing there?
Well, the judge said anyone with a pulse and a license, as far as he's concerned, can do this. Now, I don't think the judge wants to get into that and allow that to be an issue in this case. He wants them to stick to the narrow definition of a conflict of interest. But, it is coming up. It has come in. It has been discussed, and he has allowed it. And no one here is saying that Nathan Wade has the experience that other prosecutors have, right? No one's saying that. But on the other hand, the prosecutor's saying, well, they tried to hire two other people, to come in and do this, and they didn't want to do it. So she wasn't really trying to hire her boyfriend, right? She tried other people first, and then she eventually hired Nathan Wade. But what her reasoning was for that, we don't know.
Yeah, as Sado had said, he wants to focus on the motive, and at this point, it's still all conjecture because, you've just got to piece it together, and I guess that's what the judge will be doing. Right. We've got to wrap up here. Thank you so much, Arlene. Always great to speak with you on our analysis, and great to hear your insights. We'll be hearing shortly from our next guest, Paul Kamenar. He's lead counsel at the National Legal and Policy Center. All right, Paul, great to have you with us. Thank you for joining us today. I want to look specifically at some of the closing arguments on the prosecution side, but before that, what do you think of the closing arguments and the rebuttal by Sado on the defense's side?
Well, I think the closing arguments on the defense side were excellent. All the defense attorneys did hit the prosecution's case with the hard evidence, the one by Wade, who his law partner, who said absolutely their relationship began before he was hired by Fani Willis. So I think they did an excellent job of showing that there is a conflict, and that at a minimum there's an appearance of conflict, but they made a good case why there's an actual conflict. And respect to the kind of conflict, it could be either financial or a personal relationship, a personal interest that they had. So there was conflicting evidence about the use of the cash, but the defense attorney said, hey, look, we made the argument, and it's up to them to come back with the withdrawal receipts from her account showing where she was getting all this cash. To be sure, there was one vendor who said, oh, she did pay $400 for this wine tasting that they had in Napa Valley. But where's all the other evidence? She's drawing, $9,000 or $2,500 that she's magically pulling out of her purse to pay back Nathan Wade for these trips. There's got to be a paper trail, and they didn't come up with it.
Yeah, this
so
kind
I think there's enough there for. Go ahead.
Well, this kind of makes me wonder whether there are how many other people may be lying in wait who have a story to tell about this, what they've witnessed. And we heard from the prosecution side in their arguments that there were many people who were subpoenaed and didn't show up, and they kind of put that forth as proof that there wasn't anything for those people to say, or that they would be willing to say. What do you make of that argument?
That happens all the time, where there are witnesses who do not want to get into the public spotlight of a high-profile case such as this. But again, I think the evidence was fairly compelling, and the judge, sort of kept his cards close to the vest here. It's hard to say which way he's going. We'll know in a couple of weeks. But clearly, I think there's enough to go after both Willis and Wade in terms of the ethical violations, for bar complaints, for maybe lying before the court, not having candor before the court, in terms of the amount of financial interest, the question of materiality I thought was interesting. The judge did make a hypothetical. Well, how about if she got a stick of gum? Does that count as a gift? And obviously not, because we say in the law there's a Latin saying de minimis non curat lex, meaning the law does not concern itself with trifles. But once you get up to like $100, which was the level that she has to report on her gift disclosure form, I think you're getting materiality. And clearly this was over $100, and they showed up to $9,000 worth of transportation and travel, et cetera.
Yeah, and as one of the lawyers also mentioned, that Nathan Wade is a forbidden person, as in he works for the district attorney's office, so he absolutely should, that Fani Willis should be documenting all of the expenses exchanged between them, or at least the expenses that laid out or that she's accepted from him. And you mentioned about the potential for what kinds of consequences for Fani Willis, also for Mr. Bradley. We do see that there's, we spoke with a guest earlier, David Gelman, who'd said that, Bradley's been impeached, his credibility is gone now, and I wondered what you think consequences could be for him.
Well, yeah, he's got a problem there as well. So I think there's enough improper conduct to go around for everybody here. But at the end of the day, there has to be an appearance of a conflict that makes this case have a problem. And no matter what the judge does, I think the public already sees the stain of a conflict and an appearance of impropriety here. And I think that makes the whole case very difficult for the prosecution to go forward. So we'll see what happens, but like you said, there are other misconduct complaints that are collateral to this, whether there are bar complaints, whether there's perjury charges that may come from this and all that. But whatever the court rules here, I think this case is fatally wounded.
And of course, as you mentioned, so the bigger question here is what happens to the case against former President Trump and so many other cases that could be impacted around the country as well. One of those things may be just in terms of this hearing about the timing of the broader case. How do you see that potentially playing out?
Well, that's right. I mean, today there was a hearing in Florida on the Mar-a-Lago case where the court there, Judge Eileen Cannon, did not set a trial date in that case. The prosecution wanted July 8th. The defense attorneys wanted to put it in end of August, September. But I think that one will be put off because that case also raises an immunity issue, which was also raised in the case here in D.C. And the Supreme Court is taking that case. And we won't know until the end of June. So I think those two cases are basically on hold. So the only one that's left standing, so to speak, is the one in New York with Alvin Bragg. And if you're going to have, from Trump's perspective, one case to go first, I think he would want that one because, in my view, I think that's the weakest of the four cases.
Oh, interesting. Could you tell me more about that? So obviously he's appealing that right now, but it looks like he's going to have to pay that. How do you see that potentially?
Well, no, just to be clear, I think you're talking about the New York civil case in terms of the tax liability.
Oh, I see.
I'm talking about the hush money case, the Stormy Daniels one.
Yes.
And that's supposed to take place at the end of March. And I think that one is very weak because what you have there is another local prosecutor who, like Fani Willis, also vowed to go get Trump while they were running for their respective offices as DA. So I think there's a political and selective prosecution going on there. But Alvin Bragg's case is very weak because he's trying to take basically a New York law that deals with how businesses are to report their expenses on their business records and bootstrapping that into a federal election case. that money was actually used to pay off Stormy Daniels, and that somehow affected his campaign. And he violated the election laws by making a contribution to himself, which is ridiculous to begin with. But more importantly, both the Federal Election Commission and the Justice Department declined to prosecute Trump on a federal election law. So I'm not sure how Alvin Bragg is going to try to make a federal case, literally and figuratively, out of a local two-bit misdemeanor bookkeeping error.
Yeah, interesting. So we heard on the first few days of the hearing here down in Georgia, in this part of the hearing, that Fani Willis had said something to the effect of that she took cash out of her campaign, some of her previous campaign funds, and that's how she had some of her cash on hand. And now we're talking about former President Trump and, contributing money to his campaign almost in reverse. So it's an interesting thing to kind of position next to each other in terms of the law being something that's meant to help uphold morality. We don't know the full details of what Fani Willis said, but that was her statement in the hearing.
Yeah, that is interesting, because you can't use campaign but at least I know at the federal level, for personal use. So if she did that and there's a state law against that, she's in some trouble under Georgia campaign finance law. But it's perfectly legal, and the Supreme Court has ruled in Buckley v. Vallejo that a candidate can give unlimited amounts of money to their own campaign, because the whole purpose of limiting contributions is to prevent corruption. You don't want secret people giving you millions of dollars so you vote on a certain way for their pet project. But, if you're giving the money to yourself, the court ruled, you can't corrupt yourself. So in Trump's case, I don't see the violation here, because even if they ruled that what he gave Stormy Daniels was an illegal campaign contribution, well, under the election laws, the remedy is to give that money back to the donor. Well, the donor is Donald Trump. So that whole case just makes no sense whatsoever.
Right, and you're pointing also to this idea of things being covered up. If it's wrongdoing, it's naturally going to be tried to be covered up. And we did see the defense attorneys in this Fulton County hearing pointing to in Mr. Sadow in his final arguments, saying that he pointed to the fact that there was no evidence except for phone records that Nathan Wade and Fani Willis met up in person many times allegedly at Miss Yurty's condo. And he said that the lack of evidence reinforces his argument that they knew that they were doing something wrong. Whereas on obviously the prosecution side, they said there was no evidence and therefore there was no wrongdoing. It's a double-edged sword, I guess.
Yeah, right. I mean, the phone records is problematic, because they said that you need an expert to determine whether the data makes it show that both phones were in the same proximity. So I could see the judge having some problems with that. But again, the burden is on the defense attorneys here to make the case. And I think they met their burden, and that it shifted to the prosecution to rebut that. But I think they didn't do a good enough job to rebut that. So I think the judge is now has the case before him. I think he's got to do something. I can't see him saying, no harm, no foul, let's get on with the case. There's got to be some repercussions one way or the other here.
Yeah, and so finally, Paul, I just wanted to check in with you. Fani Willis is the only prosecutor who has brought charges against former President Trump himself. Despite there being half a dozen swing states that are conducting criminal investigations into the election of 2020. What do you think? What do you make legally of the RICO arguments that Fani Willis has brought?
Well, yeah, the whole RICO argument is really ridiculous. This is not a RICO type conspiracy. I think the reason she brought it against Trump because of the phone call he made to the Secretary of State there, Raffensperger, about that famous call where he says, find me these extra votes. But again, that is basically not evidence of illegal tampering with state election laws. I mean, Donald Trump had a First Amendment right, just like any other citizen, to petition for redress of grievances. And he was exercising his right to contact the Georgia saying he's got evidence that there may be some election fraud going on there, and he's asking the Secretary of State there to take a look at it. And so, you know, that was perfectly legal on his part, but yet Fani Willis and others are twisting that to saying, aha, here you are trying to corrupt the system. So I think, you know, she's going after him because he did make that call.
There are so many ins and outs to all of the legalities of all of these cases. It's almost too much at times, but thank you so much, Paul Kamenar, lead counsel at the National Legal and Policy Center, for making some of this clearer for us. Thank you so much.
Thank you for having me. My pleasure.
All right, and we are tuned in to, we've just been spending quite a few hours covering the hearing in the Fulton County, Georgia case. That's, of course, the misconduct hearing against Fani Willis and Nathan Wade, looking into whether they acted improperly in their professional course of their profession, targeting former President Trump in the Georgia election case there.
And the ruling here will determine whether Willis and her entire staff will be disqualified from prosecuting this case. And the question remains, if that's the case, would someone else take up the case here? Would another DA be willing to take up this case? And what's the delay now? It's already going to be delayed 2 weeks because the judge is considering these arguments. So we know this is going to be delayed here, but how long will it push it for?
That's true, and time is of the essence at this point in time. You know, there's no sense really of when this decision could come out, but yet still the election inches closer day by day. So there's a lot to that.
Well, I would like to go over a few key takeaways from the hearing. Okay, so what was the prosecution arguing here? That one of their main arguments was that you know, Willis was paying back Wade the money that he was making from the state in his prosecution here, but there's a deficit of $9,200, and there's no receipts, so there's no paper trail to back up their arguments that that was paid for. They said that, you know, she did benefit financially, but she did pay back certain amounts. That's what the prosecution's arguing here. We have the relationship. The prosecution says it started in 2019. One of the things that really set the defense off, in my view, was the arguments about the church congregation when Willis was making those claims that it was involving race. They were going after Wade because he was black, and that she was going to win, you know, the case here. That's what they were arguing, is what she was saying. But you know, we don't have an exact response here. We have the rebuttal from the prosecution side saying that there's no these evidence does not actually prove these claims. And so we'll just have to see, you know, what comes out of this. We have phone records, but again, the prosecution here is saying that these phone records are not, they can't pinpoint the exact location here. I've also heard arguments that they can the other way. So I'm no expert in the AT&T phone records here, but so also the defense here needs to prove the appearance of impropriety, and that's different from you know, proving that they were actually committing you know, impropriety, just the appearance of it, and that they should be held to that standard, while the prosecution's arguing that they don't need to be held to that standard, that's more for judges.
Yeah, there was a lot there where the judge was probing, especially during the defense's closing arguments about case law, you know, what Georgia law could help determine his decision. And it looks, I hadn't realized until today, it looks like there may be arguments on both sides as to whether it could be just the appearance matters or whether the actual misconduct matters.
Mm-hmm. Yeah, so we'll have to keep going and wait as far as the outcome here. And you know, what were your you know, initial reactions to this, and how the judge was taking this stuff?
Yeah, there's a lot to speak about.
Yeah, going over how the judge reacted. You know, it seemed like he was going back and forth with the defense attorney, as well as with the prosecution, quite a bit there. There was a lot of controversy related to Yurdi and how Yurdi did not want to appear on for the subpoena when she was subpoenaed. The prosecution here was arguing that Yurdi did not want to appear, and there was a lot of back and forth there.
There was a lot. Actually, I hadn't realized that about Miss Yurdi. She was quite willing by the time she came to the stand. In contrast to Bradley, most of the other witnesses were willing, but so there seems to be a lot of back and forth. But next we're going to tune into another legal expert we have for analysis, Gerard Felitti, Senior Counsel at the Lawfare Project, for his take on what's been happening today. Welcome, great to have you with us, Gerard. Always great to speak with you. Gosh, there's so much happening today, and in all those closing arguments really paints the picture of where both sides are coming from. Do you see, I want to dig in a little to the arguments on the prosecution side, but do you see any holes or anything that was missed on each side?
I think both sides did a very admirably thorough job of addressing their side of the case, but there are diametrical differences and oppositions in how they interpret facts and even whether they acknowledge that some things happen. And ultimately, that's what the judge is going to look at. But the arguments were the same ones that we've been hearing throughout this proceeding. There were no real surprises, and it's still as dramatic as it was going right on down to Fani Willis's body language and the observations made by the judge. So really, it's all what we've seen in the last week, we see it condensed today, and that really made for a great show.
And of course, the prosecution wanted to, in their closing arguments, discredit the testimony of Bradley and Yurdi, and they tried to do that. They said that Bradley had motive to lie, and I wondered whether you thought that argument was made convincingly.
I think the argument was the argument you'd expect. I don't think that it was as convincing as they would have liked it to be. I think that the testimony itself came across as convincing, came across as these witnesses came across as having integrity and not ones that wanted to be in the limelight and in the spotlight and to testify about this. They were reluctant to be involved, and when they did testify, they certainly appeared convincing and genuine. So I think the attempt now is the attempt that needs to be made to strike their testimony essentially as not credible. But I don't think the prosecution convinced the judge on that.
And a little more on the details here from the prosecution side. Of course, they pointed to the range of other witnesses that came up and supported Wade and Willis's testimony about when their relationship started and whether cash was being paid or not. What do you have to say about the strength of the other witnesses in contrast to Bradley and Yurdi?
I think the only witnesses, perhaps, that were not as compelling were the main parties themselves. They seemed to be having a lot of difficulty testifying. The stories that we got from the witnesses, in large part, even for the inconsistencies as to when they met and what cash transactions were happening, you still got the story that these are two people who were intimately involved. These were two people who did travel together, who did engage in activities together. There seems to be no dispute, even from Fani Willis herself, that cash changed hands. So the overall story that we're getting is that there is definitely something that happened. Now, the exact details are important, but ultimately they're not as important as the credibility of Fani Willis herself and whether she has been influenced in her decision-making ability by what has transpired in the relationship with her and Nathan Wade.
And Mr. Sato, I believe it was, one of the defense lawyers had said that the potential consequences of this hearing could be that the Fulton County District Attorney's Office could become a laughingstock, and by association, the case itself and the legal system in America, he sort of insinuated. How do you see the broader impacts of this hearing?
For many years, lawyers are held to a standard of avoiding conflict and avoiding impropriety. And for many, many years, the standard is that the appearance of impropriety is enough to get a lawyer disqualified and because it looks bad and it affects their credibility and ability to present for their clients. Now, this is what's going on here. You have two lawyers prosecuting Donald Trump who clearly were involved in a personal relationship, reluctant to talk about it, and you have questions about their judgment, and you have the appearance of impropriety. Now, whether or not Fani Willis is ultimately removed from this case, this will stay with her. This will stay as a blight on her record, essentially. Not her professionalism, but her ability to be an honest and integral part of the court system. So there was a lot of damage done to her reputation on that.
Right, and also potentially on the case itself, there's some impacts there. Just briefly, if you'd like to touch on that.
Well, the impact on the case, I think, is more from what we didn't get into in this particular set of hearings. It's the contact that Nathan Wade had with the Justice Department and the White House, and whether he did so and in what capacity he did so, what was communicated there. And we know that Congress is already salivating to find out. I think that sort of evidence, if you will, would have more of a bearing on the conduct of the trial than the personal relationship. The personal relationship just goes to judgment. Is this politically motivated or not? We don't really know from this hearing, but we do know that Fani Willis's judgment is not as good as we would expect it to be.
Right, and you're referring to meetings that Nathan Wade is known to have had with the White House at specific points of time during this whole court case. Is that correct?
Correct. Mm-hmm. Correct. That's probably the more revealing testimony that came out of this, and everyone wants to know what happened in those meetings, how were they called, who initiated them, who was present in the room, because that in many ways goes to Donald Trump's argument that there is political motivation, or that there is, I don't want to use the word witch hunt, that's not the right word, but there is a gathering of forces to make sure that he's prosecuted. And that really is something that needs to be looked into, because it does affect the integrity of these prosecutions, even if it doesn't affect the facts of what Donald Trump is accused of having done.
Yeah, and one of the related cases that Donald Trump is currently facing is currently being reviewed by the Supreme Court. They've taken up the question of presidential immunity, and that, of course, impacts many other cases that are currently in play. And that pauses a number of the cases around the country that are accusing Trump of insurrection. How do you see the next steps going forward on that case, and how could this impact the optics as the election draws near?
Well, I think the Supreme Court may not come out with a definitive ruling on presidential immunity. Based on decisions that have come out in the past from other courts on judicial immunity, presidential immunity, executive powers, judicial powers, which are very parallel in legal arguments, the Supreme Court is likely to come to a conclusion that this really is very fact-specific. And someone needs to look at the facts of what Donald Trump is said to have done or not done, that someone being a jury or a judge at a lower court. So I think the Supreme Court might well take a look at this issue, consider it carefully, but not make a final decision, instead waiting for a lower court to come to evaluate the facts and the circumstances and issue a ruling.
And which other cases would you say would be worth really training our eyes on and keeping an eye on in terms of what Trump is facing right now?
I would say, honestly, the biggest case is Florida. There is much more of a black and white approach to classified documents. And there it's much simpler. He definitely had, there's no dispute that he had documents in his possession that were classified. He has admitted this himself, essentially. The issue is whether he was entitled to have them or not have them. And the corollary is whether he showed them to any people, disclosing them, which is a separate crime and separate allegation. So I think that is a very nuanced. It's not as nuanced as the charges that he's facing in D.C. federal court. It's not as nuanced as what's going on in Georgia. It's much more straightforward. And perhaps that is one of the reasons why we're looking at the battle right now on whether the case will be heard in July or August or pushed off until after the election.
Right, and just back to Georgia, Sadow, Trump's defense attorney, had said that Willis's church speech that she gave really had the effect of spurring the media on to associate the defendants with racism. So it really points to this effect, they were saying, of the role of the media as well in spreading public opinion. Of course, that's well known, but sometimes these things tend to backfire, and I wondered, taken together with all of Trump's cases currently as they're moving forward, what do you think it could be communicating, and how could it shift public opinion potentially?
Well, one parallel that should be drawn is what happened in D.C., where the judge in that case, Judge Khan, had also made comments when she was sentencing other defendants related to January 6 charges that seemed to suggest that she held a certain view of Donald Trump. And that raises the question of whether she can be impartial in adjudicating and conducting the trial. And between that and between Fani Willis, in her statements, there certainly is the question of how impartial and how open-minded these prosecutors are, and whether they have a mindset that predetermines them to look at Donald Trump as having committed a wrong, or whether they're truly looking to investigate whether a wrong was committed in the first place. And that is troubling, because that goes to the question of, is this a politicized prosecution, or is it a fair and legitimate trial on merits?
And Seydow spoke quite a bit at the end there about motive and wanting to look out for exactly who has the strongest motive. Of course, he was saying Wade and Willis did, but all of the defense attorneys really pointed to two forms of motive, one being romantic and one being personal ambition in terms of financial. What do you think are the strongest arguments there? It doesn't matter what the motive is.
I don't think it really matters what the motive is. What matters is the appearance to the public that there is something not straightforward going on, that these people were less than honest in their disclosures and in the nature of their relationship and their finances. And I think an important point to be made is the financial aspect. Having done counterterrorism finance litigation, hearing stories about cash changing hands in the manner that it's alleged to have changed hands, and expenses that are not borne out by receipts, or withdrawals that are not borne out by documentation, you have to wonder whether this was a tax avoidance scheme, whether this was a transfer of money illicitly done to avoid paying taxes. And I think that we will see in the future investigations on that part of it as well.
Yeah, fascinating. I mean, I guess what I'm wondering is, Fani Willis, I read this morning in the New York Times someone who was quoted saying, what's the relevance anyway of the motives? Because if they believe also that former President Trump should be prosecuted for this, what they're saying is a crime, then it's still a righteous endeavor. What do you have to say to that? And just briefly.
I think we expect our prosecutors to look at a case on the merits, not to be predisposed to saying we want to bring charges against someone because we don't like them. Let's find a law that works. You want to look at what's alleged and be fair and see whether it applies, whether it violates any law. And that's really where motive comes in. If they had bad motive, then they're looking to find something to get Trump on, as opposed to looking to see if he actually did something wrong.
All right, thank you so much. Paul Kamenar, lead counsel at the National Legal and Policy Center. Always great to speak with you. Thank you. Oh, I'm so sorry. I'm so sorry. We did speak with Paul earlier, but of course, Gerard Felitti, we speak often. So senior counsel at the Law Firm Project. Thank you. I'm sorry for that.
Thank you so much.
Thank you, Gerard. And that concludes our special live coverage of the Trump trials for today.
But don't go away. NTD's Capitol Report is coming up in just a moment with more coverage of the Georgia misconduct hearing. That's at 5 p.m. Eastern. Thank you, and see you soon.
Is deep-sea fish oil really healthy? Due to pollution in the oceans, most fish contain heavy metal elements and radioactive substances. That's why it's so important to choose a pure source of omega-3. Puritang green vegetable omega-3 is made from purslane and perilla seeds, which are rich in nutrients and minerals, especially vitamins A, D, E, calcium, and iron. With natural processing and no harmful chemical additives, it has more than 90% concentration of omegas 3, 6, 7, and 9. It effectively improves brain power and is beneficial to the heart's health. Puritang omega-3 does not smell of fish and contains no pollutants, so both adults and children can safely and easily consume it over a long period of time. Puritang green vegetable omega-3, greener, healthier, and more effective. Visit puritang.com to learn more.
As we naturally age, many people are getting zero amount of this incredible and unique substance. That's when we start seeing an impact in our joints, skin, nails, and even our digestion.
People ask me, Dr. X, what is the #1 supplement I should be taking? My answer is multi-collagen protein.
People's reactions to me, people were like, what are you doing? What is going on? You look amazing. You have a glow about you.
What makes Ancient Nutrition Multi-Collagen stand out from other brands? 10 types of collagen. It's grass-fed, pasture-raised with vitamin C and probiotics. It's proven to reduce exercise-induced joint discomfort as early as day 1 and reduce joint discomfort rapidly, continuously, and persistently.